Okay, we're good on that side. Julianne, court reporter. Okay. Counsel?
I don't know where our counsel's at.
Good morning, ladies and gentlemen. This is the public meeting of the Utah Board of Oil, Gas, and Mining held January 31st, 2018. We're waiting for Division Counsel. We'll just take a minute then. Okay. We are at agenda item number 1, docket number 2017-027, cause number 139-150 in the matter of NEWFIELD Production Company. We'll take appearances of counsel at this time.
Fred McDonald of McDonald & Miller on behalf of the petitioner NEWFIELD Production Company.
Steve Alder with the Utah Attorney General's Office for the Division of Oil, Gas, and Mining.
Meg Oswald with the Utah Attorney General's Office for the Board of Oil, Gas, and Mining.
All right, thank you. Mr. McDonald, would you proceed?
Thank you, Mr. Chairman. With me today, I have Mr. Reese Cook, who's Senior Landman with NEWFIELD Production Company, Mr. Riley Brinkerhoff, who's the Staff Geologist for NEWFIELD, and Mr. Mike Jensen, who is the Retired Engineering Advisor for NEWFIELD and is now Consulting Engineer. And I ask that they be sworn in as witnesses at this time.
Okay, court reporter, please proceed.
What you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Chairman, members of the board, the resumes of all three witnesses were submitted collectively as Exhibit A in this matter. If they were separately asked, each would verify the contents of their resumes as true and correct. Mr. Jensen has previously been recognized this board as an expert in petroleum engineering on many occasions, and we ask, presuming the division has no objection, that the board again recognize him as such for purposes of this cause.
Any objections of the division?
To Mr. Jensen being recognized as an expert, no.
Okay. Board members, any objections to that? Mr. Jensen is well known to the board, and he is admitted for the purposes of this hearing as a petroleum engineer and for expert testimony.
Okay, thank you, Mr. Chairman. Mr. Brinkerhoff has not testified before the board, so we will qualify him to be recognized as an expert in geology at the commencement of his testimony. Mr. Cook will be testifying as a fact witness only. Also, I'd like to confirm, consistent with board's previous policy, that I will move for admission of exhibits at the end of our presentation.
That's our preference. And then witnesses, just so you know, in Utah, we record all of the testimony. I have a earpiece to make sure I can hear it being recorded, but you really have to speak closely to the mic, and it also assists in the streaming of these presentations to the public. So if you're not almost touching the mic, you're doing it wrong. Thank you.
Mr. Chairman, members of the board, today NEWFIELD is before you requesting essentially an extension of the board's previous order entered in cause number 139-134, which involved NEWFIELD's Central Basin area and which established 1,280 acre or substantial equivalent drilling units for Lower Green River-Wasatch Formation production. This extension goes now today to the area directly to the south, which NEWFIELD refers to as its Mighton project, or prospect, excuse me. The Mighton prospect is currently unspaced and subject to the general well siting rule, which is Utah Administrative Code Rule R649-3-2. A true and correct copy of the 139-134 order was submitted as part of Exhibit B. NEWFIELD also requests that the board take judicial notice of the testimony received and the exhibits admitted into evidence at the 139-134 hearing pursuant to Utah Code Annotated Section 63G 4-206, subparagraph 1B, Romanet 4. A true and correct copy of Rule R649-3-2 was also included as part of Exhibit B for the board's reference. There are, however, some requested modifications from the 139-134 order. First, NEWFIELD seeks approval to drill up to 40 long lateral wells on each unit, with no more than 8 such wells in any one producing interval. Under the 139-134 order, only 17 such wells were authorized. The justification for the increase will be addressed in today's testimony. Second, in connection with cause number 139-145, NEWFIELD seeks establishment of a special sectional drilling unit for the Knoll 13-10-4-2-15-7H well, retroactive to its date of first production, which was September 7, 2017, and a declaration that the well was drilled and completed at a legal location. True and correct copies of the board's 139-145 orders are also collectively attached as part of Exhibit B. Similar to the 139-134 order, NEWFIELD does not seek overlapping drilling units for vertical, short lateral, and long lateral wells. Instead, NEWFIELD requests that production from existing vertical, directional drilled, and short lateral wells remain on a wellbore basis and, as to the Knoll well, on a sectional basis until the first long lateral well is drilled, and then, effective as of the first of the month following the date of first production from that long horizontal well, providing for production from all wells to be on the 1,280-acre drilling unit basis. This will prevent premature and unnecessary modification of existing rights to production until such time of the drilling of the first long lateral well actually occurs and mandates a modification. Again, the technical justification for conversion will be addressed in testimony today. Also similar to the 139-134 order, NEWFIELD is requesting authorization to drill up to 8 vertical, directional, or short lateral horizontal wells per drilling unit, or to the extent that 8 or more such wells already exist, to prohibit further drilling of those type of wells without prior board authorization. This will ensure maximum recovery of resource from each drilling unit. Since Indian and allotted mineral lands are involved, communization agreements are required, and the BLM and BIA, whether under guidelines or practice, require a spacing order from the board to allow approval of such communization agreements. This is another reason that NEWFIELD is before you today. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the Mighton area, to the working interest owners, including unleased owners in established drilling units, or if unspaced, the quarter-quarter sections adjacent to the affected area, and this is due to the requested setback reductions, and to the Division of Forestry, Fire, and State Lands, the School and Institutional Trust Lands Administration, the Bureau of Indian Affairs, and the Bureau of Land Management, being the governmental agencies having oil and gas jurisdiction over many of the lands. The mailings were sent to these parties at their last addresses disclosed by the relevant agency and Duchesne County records. Many were returned as undeliverable. The record will reflect that notice was also duly published on October 1st, 2017 in the Salt Lake Tribune and Deseret Morning News, and October 3rd, 2017 in the Uintah Basin Standard and Vernal Express. The Vernal Field Office of the Bureau of Land Management filed a letter in support of NEWFIELD's request with the board on January 25, 2018. To the extent that letter is not already deemed part of the record, NEWFIELD requests that it be admitted into evidence as Petitioner's Exhibit O. The division elected not to file a staff memorandum in this cause, and no other objections or responses were timely received. However, EP Energy filed a letter with the board this past Monday requesting that the board instead adopt overlapping drilling units for vertical, directionally drilled, and short lateral wells, rather than conversion to 1,280-acre drilling units for all wells. However, as evidenced by the certificate of service on file in this matter, EP Energy was mailed the request for agency action in September of 2017, and therefore NEWFIELD requests EP Energy's letter be given no evidentiary credence as it was untimely filed. With that, I will commence my examination of Mr. Cook. Mr. Cook, would you please state your name and business address for the record?
Reese Cook, 24 Waterway Avenue, Suite 900, The Woodlands, Texas, 77380.
And what is your current position with Newfield?
I'm a senior landman.
And do you have working responsibilities with respect to the area at issue today?
Yes.
Okay, would you please provide for the record the corporate and bonding status of Newfield?
NEWFIELD is a Texas corporation in good standing with its principal place of business in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies.
Mr. Cook, I'm now going to direct your attention to what have been marked as Exhibits C through G for purposes of this cause. Do you recognize these exhibits?
Yes.
Were they prepared by you or Newfield personnel with your input and review?
Yes.
Okay, directing your attention to Exhibit C, which is a two-page exhibit, and particularly Exhibit C1, which is shown on the PowerPoint right now. Would you please explain to the board what this represents?
Yes, the area with the red boxes is the proposed Mighton spacing area that we're here to discuss today. If you'll notice, it is located just south of the city of Mighton. There are currently 54 producing and 16 shut-in vertical or directional drilled wells and 2 producing short laterals, one of which is the Knoll, which we'll discuss here in a little while. All of these wells are producing from the Lower Green River-Wasatch, and all are operated by NEWFIELD except for one. The easternmost 7 DSUs in the area are all 100% tribally owned sections, so therefore the production allocation is the same on a wellbore or sectional basis. JMD Energy Incorporated operates the one other well in the area, but it has been shut in since September of 2016. The parties are currently in negotiations, but we'd like to note that they have not protested or raised any objections to the hearing yet. Production from all of these wells, except for the Knoll, are currently on a wellbore basis since the entire area is unspaced. The other short lateral well in the area is drilled on the 100% tribal section, so the production allocation is the same on the wellbore or the sectional basis.
Okay, directing your attention now to Exhibit C2, please explain to the board what this represents.
Exhibit C2 is a zoomed-in version of the southernmost part of the requested spacing area. If you'll note, sections 26 and 27 are comprised of 4 small lots each, and we are requesting that section 26 be included in the sections 14 and 23 spacing unit, and sections 27 be included in the 15 and 22 spacing unit, so that those lands are not orphaned or stranded by development. Just directly to the south of this is the Greater Monument Butte unit, which NEWFIELD operates.
All right, directing your attention now to Exhibit D, would you please explain to the board what this represents?
Exhibit D is showing a zoomed out picture of the basin and the currently approved spacing orders. The red hatched area at the bottom is the Mighton order we're here talking about today. Directly to the north is cause number 139-134 in the blue hatched area. This is the first 1,280 acre space drilling units, and this area has no overlapping for vertical or short laterals, and NEWFIELD is the operator in this area. Directly to the north of that are cause numbers 139-138, 139-140, 139-143, and 139-149. These areas are operated by Axia Energy. And then the pink hatched areas on the easternmost and westernmost sides of the map are 131-150 and 139-151. These areas are operated by Crescent Point. And I'd like to point out the easternmost pink hatched area. On the map it says 131-151. That should actually be 131-150. So we'll get a correction made and submitted on that exhibit. All of these areas are spaced for 1,280 acre drilling units for the Lower Green River-Wasatch production. Axia and Crescent Point orders provide for overlapping 40 and or 640 acre drilling units for vertical and directionally drilled or short lateral horizontal wells. Mike Jensen will address here in a little while why NEWFIELD does not agree with this production allocation and prefers the conversion method.
Okay, now addressing your attention to Exhibit E, would you please explain to the board what this represents?
Exhibit E is a working interest breakdown of all of the 24 DSUs within this area. If you'll note that Newfield is the majority working interest owner in all of these spacing units.
Okay, now directing your attention to what has been marked as Exhibit F, would you please explain to the board what this represents?
Exhibit F is a closer look at the Mighton spacing area again. The purpose of this is to show that 23 of the 24 DSUs contain tribal or allotted minerals and will require a communitization agreement. The only outlier is Section 3 and 10 and 4 South 2 West, as that is 100% fee DSU. In our experience, when dealing with Indian or allotted minerals, the BLM or the BIA regulating agencies require a spacing order to be approved in order to approve a communitization agreement.
Okay, would you address to the board what does Newfield do in filing APDs and certifying to the division with respect to off-unit surface locations, and what are its practices as far as casing and cementing to hit appropriate setbacks?
Currently, Newfield certifies to the division that all horizontal wellbores will be cemented and cased as to the productive intervals within the established setbacks. We also certify to the division that Newfield has obtained all requisite surface and subsurface consent and authorizations for any off-unit drilling surface hole locations. And this is as requested within the RAA.
So in other words, you would adopt the same practice, and this is the same practice that's set forth in the 139, 134 order?
Yes.
Okay, I'm going to refer back now to Exhibit C1. Could you outline for the board again what is the effective timing of the creation of the 1280s in relation to existing production in these drilling units?
So any DSU where there has been no drilling, the effective date will be the date of first production of the long lateral well. Any DSU where there is existing short lateral wells but no long lateral well, the effective date for the vertical and short lateral wells will be the first day of the month following the date of first production from the long lateral well, and the effective date for the long lateral well will be the date of first production. However, we are requesting that the reduced setbacks for horizontal wells be effective immediately.
Okay, as the board is aware, in the 139, 145 matter, there was some issues involving the Knoll well, which is within this proposed area. Can you kind of outline for the board what the issues are and how that will be resolved by this request?
Yes, the Knoll well is a short lateral well that we drilled in Section 15 in 4 South 2 West. In order number 139, 145, we initially sought and received board approval to drill the well with 330 north-south setbacks and a 660 west setback. However, during the drilling of the wellbore drifted and deviated to a maximum of 54 feet from the western setback, resulting in 606 feet from the west line. Newfield then sought and received an emergency order from the board, allowing Newfield to complete the well as drilled, but requiring Newfield to suspend all proceeds from production pending the hearing of this cause. In accordance with that order, Newfield completed the well as a producing well within the Lower Green River-Wasatch Formation on September 7th, 2017. All production proceeds have been suspended. Newfield's requesting that the board deem this well to be drilled and completed at a legal location, especially since within this RAA, if granted, we will be within the 560-foot western setback. We also, until a long lateral well has been drilled within sections 15, 22, and 27, we are requesting that the board create a special sectional drilling unit for the knoll comprised of just section 15 and allow the allocation of production on that basis retractive to its date of first production. A sectional drilling unit is consistent with previous board orders for nearby lands for short lateral wells and, in our opinion, protects correlative rights.
Okay, I'm now going to direct your attention to Exhibit G. Would you please explain to the board what this represents?
Exhibit G is illustrating the areas of notice. The red hatched area, all production interest owners were sent a copy of the RAA and notice. The blue areas outside, all the working interest owners and unleased mineral interest owners received notice of the RAA. These comprise of established drilling units and adjacent unspaced quarter-quarter sections adjacent to this area. And the large blue area just to the south is the Greater Monument Butte unit that Newfield operates. All the working interest owners within the unit received notice also.
And again, the adjacent working interest owners were notified because of the reduced setbacks that you're requesting, is that correct?
Yes.
Okay, I'm going to show you now the certificate of service and the supplemental certificate of service that was prepared by my office based on information from you. Do you recognize these names and addresses?
Yes.
And who are those parties?
They are the parties illustrated on this exhibit within the blue and red hatched areas.
Okay, and how were those names and addresses compiled?
They were compiled from a combination of Newfield internal land records, title opinions, and county courthouse research from our brokerage firm, Lone Wolf Energy.
And the agency records as well?
Yes, yes.
Okay. As reflected in the certificate of service and the supplemental certificate of service, my office certified that these were mailed, regular mail to those parties as indicated. With that, that concludes my examination of Mr. Cook.
Are you going to designate an exhibit number? Is that exhibit Z, or what do you?
No, there's no exhibit Z because it was not sent certified mail this time. But the certificate of service is a pleading already on file with it that certifies that it was mailed regular mail.
Okay.
Again, Mr. Chairman, that concludes our examination, Mr. Cook.
Okay, division.
Good morning, Mr. Cook. The division has a few questions. With regard to Exhibit C1, could we put that up, and we'll kind of go through the exhibits in the same order that you presented them. I just wanted to verify, did you say that all of the wells that are indicated in the area that's proposed to be spaced are operated by Newfield but one?
Correct. So
all of the vertical and then the one is a horizontal well, is that right?
There's two short horizontal wells, 4 South 2 West Section 15 and 4 South 1 West Section 8.
And who operates the other well, and is it a horizontal or a vertical?
The other well is a vertical well operated by JMD Energy. It's located in 4 South 3 West Section 4.
So are there other potential operators within this drilling unit that might in the future drill short or vertical or long horizontal wells?
I do not believe so. We own the majority working interest on this in the section, the full 640 section, and the 1280 DSUs across the area.
Well, I thought Exhibit E is it Exhibit E that indicates that you have only 50% interest in some drilling units, and looks like a maximum of 80%. Is that? Am I reading that wrong?
No, that's correct.
So how is it that there's not other people that might be potentially developing these areas?
May I confer with counsel?
If you need to.
Go ahead.
Yes, there are other companies that do own interests within this area. They would have to propose a vertical or short or long lateral well within that area, and since we do have the majority working interest, we would prefer that we operate, and so we would probably go down the path of objecting to that and desire that Newfield drill and operate the well.
So then turning back to Exhibit C1, when you say you have the majority interest of the drilling units, and we have that shown on Exhibit E, But what about the sections or the 40-acre locations where vertical wells could be drilled as they were on the eastern half? Wouldn't it be possible for operators to propose and drill vertical wells without needing your consent? Or do you know?
On each 40-acre basis, I'm not sure. But if a well was to be permitted, we would definitely reach out and try to discuss what they were wanting to do and let them know that as the majority interest owner in the 1280 basis, which we do plan on developing this area with long lateral wells, that we would prefer to operate this area that way.
So are you saying that the purpose of your objecting, if they needed your consent, or at least reaching out if they didn't, would be to persuade them not to drill short lateral wells or vertical wells? Is that what you're saying?
Yes.
And yet you're asking for a combined spacing that allows for all three wells.
Correct.
Are you the best witness to explain why you want the variability to have all three wells, or should I wait for your geology?
I would wait for a geologist or engineer.
Okay. As to the existing wells, I think that the request for agency action refers to these being spaced on a well-bore basis. Can you tell me what you mean, or what you understand your request to mean by that?
This area is not spaced, so they've been drilled under the 40-acre state rule.
And how would production be shared under the 40-acre state rule?
As it currently exists, it's just shared on the wellbore basis for the owners within that 40-acre spacing unit.
Is that the same as 40-acre spacing? Is that what you're saying?
Essentially.
Are all the areas leased on 40 acres, or wouldn't the production be based on leased basis?
I'm not sure I understand your question.
Well, if there's a 40 and a vertical well in it, but it's subject to a lease that's 160 acres, would the production be shared with all of the owners in the 160 acres or in the 40?
No, just on the wellbore, just the 40-acre.
And is that terms of your lease, your leases?
I believe that's in compliance with the state rule. The production's only to be allocated on the 40-acre unit.
Yeah, well, if that weren't the case, would it be, if it wasn't constrained by state rule, would it be based on the lease?
Mr. Chairman, I'm going to say that this is a legal conclusion. If we can move it along, I think the rule of capture applies until there's a spacing order, and there's no spacing order.
But regardless of the rule of capture or lack of spacing, there's a determination as to who shares in the production from a 40-acre well, and the statement is that it's on a wellbore basis, and that's not very clear. There's no definition in the rule. So I think he's the landman. He should at least have an opinion. If he doesn't, we'll ask another witness. I don't think it's a legal conclusion.
I think it's a proper question. Let's just make sure we're clear about it. The rule that we're talking about is a well siting rule, 40 acres. It has nothing to do with the spacing of it until it comes to the board and there's a board order. So, Mr. Alder, would you re-ask your question in light of the 40-acre siting rule, which basically is that you can't have two wells within a 40.
Right. Well, and Mr. Chairman,
or where you're trying to go with the question?
Yeah, where we're trying to go with the question is the request also asks that prior to drilling of a 1,280 acre or long lateral well, that vertical wells that are drilled subsequent to this order or existing vertical wells would share production on a wellbore basis. I think we need to know what that means.
Certainly, I think that I think it would help the board, and I think it would. And if you need some time to figure that out, but how is it normally done on a well that's drilled on a siting rule?
My understanding is that the ownership depends on the ownership of the mineral that's drilled into. So if it's a 10 acre, it's shared with the 10 acres. If it's 160 acres, it's going to share. And Mr. Moon's shaking his head.
No, the default is that 40 acre spacing, and it's shared on 40 acres. You know, your leases will almost always say it, you know, defaults to the state requirement. And that's just the way it's done. Yeah, there wouldn't ever be a 20 acre spaced well unless we had designated a 20 acre spacing.
But I think the question is production allocation to us.
It's allocated over 40 acres.
Well, if that isn't in the lease, I'm not sure that it's, I'm not aware of a rule that dictates that it's, in fact,
that's a continuing concern
as the chairman
I have.
pointed out, it's just the opposite. It's just a location.
It's just a location. There's
And since the rule of capture applies, it would depend on how the mineral is owned, in my opinion. But I think it's important going forward for the order that this board enters as to the short, lateral, and the vertical wells that are going to be allowed to be drilled. So
that's a good point, Mr. McDonald, that as we get toward the order portion of this proceeding, that we do address the allocation of production under the well siting rule as it applies to this matter.
That's fine, Mr. Chairman. I mean, if our position, legal position, is the rule of capture means what comes out of the wellbore. So it's wherever the wellbore is located. The well siting rule, from a legal standpoint, does not create 40-acre spacing.
That is
correct. It's a location situation only. So if a leasehold only covers 10 acres and that person owns 100% of that 10 acres, and that's where the wellbore is, only that owner in the 10 acres, unless there's a lease provision that says he has to share it, receives the revenue and the production under the rule of capture.
That's my understanding.
And that's what the current situation is out here because it's not
basically
spaced. Yes. That's
So
the
why are these all shared on 40 acre basis then?
Well, it could be that there's, I don't know. I mean, I'll have to ask Reese if that's the case, but it's supposed to be a lease, it's supposed to be a wellbore basis, which I think is what he testified to. My guess is there's probably no acreage under 40 acres that's covered by a lease, especially in the tribal situation, which is the situation
you have lots
in the
of
east.
leases. I mean, there's lots of leases for each 40. There, 30, 40 leases, and so just the way it's done is 40 acres. But I don't know legal justification for that.
I don't
that's,
know
that's
that
a good
that's
question.
accurate.
yeah, but if the lease is not, I mean,
Yeah,
there could be
let's
lots
ask NEWFIELD if that's accurate. I mean, don't you share these wells on a 40 acre basis? Every one of them.
Yes.
Okay. So now we got to figure out why you do that, but we do, we do it that way.
Well, and I would like to ask the witness if your proposal then and your request is that vertical wells be spaced until a 1,280 acre well is 1,280 acre well is drilled on 40 acres for vertical and 640 for short lateral. Is that what's intended in the request for agency action? Maybe your counsel needs to answer that.
If you don't mind, I would like to answer that. The request does not do that. It's keeping the status quo, the current way it is right now, for either way, with the exception of the Noel well. The Noel well, they're asking for a special sectional drilling unit for that short lateral well, and to leave it the status quo until the first long lateral is drilled, which justifies the establishment of a 1,280 acre drilling unit.
Right.
Okay, so let's restate that so the board's perfectly clear. My understanding, what you just testified, and I want to make sure we're clear on this, is that in the absence of a spacing rule, the well is produced on a leasehold basis for the lease it's on, and in most cases that is more than 40 acres, but if it were less than 40 acres, let's assume it's a hypothetical, it was 20 acres, that 20 acres upon which the well was drilled would be leased, and it would be production allocated on 20 acres. Is that your testimony? Is that the position of Newfield in
That's
this
the current
matter?
position, yes.
That's not the way it's happening, though. But you're saying go with the status quo. The status quo is.
That's the idea, is to not affect current rights to production.
So how is that spacing then, Mr. Cook? To what extent, prior to drilling a 1,280-acre well, and there are none in this area, you're not really asking for spacing to be effective until there is a 1,280-acre, because prior to that, isn't it true that it would be shared based on leases and not on any order of this board?
Yes, the 1280s will not take effect until the first long lateral well has been drilled and has been put on production.
And at that point in time, all production under the request would be shared on a 1,280-acre basis is the request.
Yes.
All right. Okay. Of course, there are some qualifications under the existing well siting rule. You couldn't drill more than one, and I just want to clarify what you understand the request to be. You wouldn't be able to drill more than one short 640-acre lateral without an order of this board allowing you to drill more than one 640-acre lateral under the well siting rule.
Yes.
So, and as to vertical wells, conversely, you could actually drill 16 wells per section, and you're asking the board to limit it to 8, but you're not going to establish drilling units for those 8 wells. You're just going to say up to 8. How is that consistent with the rules? Again, that's a legal question. I apologize for putting you on the spot.
Well, the situation again is the 139-134 order. If you recall, when we originally was requested, Newfield did not want to drill any vertical wells. And the division asked that in order to maintain flexibility to have up to 8 wells. I think the testimony so far has been, and what you will hear, is that Newfield does not intend to drill any more vertical wells unless it was absolutely necessary based on geologic reasons. So the idea that you want to have up to 8 wells is being consistent with the prior order, and in certain cases, as is shown on Exhibit C1, there are more than 8 wells already in place already, and they don't want to have the authority to have to drill any more of those. They prefer to drill the long lateral wells. So the idea here again is that this would primarily be a long lateral horizontal development, leaving some flexibility for additional wells to be drilled. You maintain the status quo until the first long lateral well is drilled, and at that point it converts to a 1280 and all production shared on a 1280 basis going forward.
Back, just again, we're trying to clarify this. So, Mr. Moon, in the hypothetical I put together, it would be the requirement of the leasehold owner in the offsetting 20 acres. So there's, again, the assumption is that there's a 40 acres split in half with 220 acres. The non-drill 20 acre would have an obligation to come before us and request that it be spaced so that they could share in production, and that's the Callan case. That wasn't an order of the board. That was a Supreme Court decision that said that the rule of capture applies in Utah. It's been a highly criticized decision, but that is what the Supreme Court gave us, and so that's the difficulty we have here. Is that your understanding, both counsel?
Yes.
Mr. Alder, is that your understanding as well?
Yes.
Mr. McDonald?
Yes.
Thank you. Back to you, Mr. Alder.
All right. So as to Mr. McDonald's statement about the existing or the request, the relief that was requested in the 149 order, the one immediately, the land immediately to the north, wasn't there already in existence an order that allowed for up to 8 wells or 4 wells per section, 8 wells per drilling unit for those lands prior to the request for agency action, if you know?
Yes.
Okay. And we're talking about actually 8 wells per 1280, so 4 wells per section is what Newfield is requesting to be allowed in this case.
For the vertical wells.
And you're not prepared to say that those vertical wells prior to the drilling of a 1280 long lateral would be spaced on 160s or 40s. They would just depend on the lease. Is that your testimony?
Yes.
I would like to turn to a different subject. If you could look to, you talked about the practices as to the certification of the requisite surface and subsurface consent. What do you understand the board's order to mean when it says that you must provide surface and subsurface consent? What does Newfield intend to do to comply with that?
A surface use agreement and a subsurface easement if it's necessary.
When is it necessary?
When
The subsurface agreement.
when the surface hole locations outside of the proposed DSU.
And is, in your opinion, is a subsurface consent different than necessary even if you have the surface consent? So if you have a surface use agreement, does that include the rights to drill a well underneath the surface, in your opinion?
Yes, it can.
And is that how Newfield interprets the certification?
Yes.
So for off-lease areas, all you need to provide is, all you need to have is a surface agreement.
Yes.
I think that's mischaracterizing his testimony. He said in certain cases that it may not be required. If the surface owner also has the subsurface rights, or you have the subsurface rights as a lessee, that's correct?
Right, if they own the minerals also.
Right, but if someone else owns the minerals and you have a surface agreement, then your interpretation is that the surface agreement, the rights of the surface owner include the rights to drill and not, as long as you don't produce mineral.
Correct.
Okay.
Again, if a third-party lessee, okay, had the mineral rights, do you get a subsurface easement agreement as well?
Yes.
Okay. In other words, if there's severed minerals, a surface use agreement alone would not cover it. You would also get a subsurface easement agreement from the lessee.
Okay, let me give you some hypotheticals
Okay,
again.
well, thank you for that. I mean, excuse me, Mr. Chairman. Go
Yeah, I
ahead.
want to make sure the board. So you have a surface off spacing unit, drilling spacing unit. You've got the well, and the surface and the minerals is owned by a single party. A surface agreement would be the permission you need to put that well off of the lease and drill it, correct?
Outside of the spacing unit, yes.
Yes. If it's a split estate, how do you handle that on the land outside of the spacing unit?
If we have a lease for the minerals underneath the surface tract, then we just get a surface use agreement from the severed surface estate and make sure that we don't produce anything outside of the approved setbacks.
Okay. And then the third hypothetical is you have a split estate and you're not the lessee of the mineral estate.
We would get a subsurface easement from whoever holds the lease for that mineral estate below the surface.
In addition to the surface agreement?
Yes.
Okay. Is there any confusion on that? Go ahead, Mr. Murray.
Yeah, from who? From just the, like that 40-acre air well bore, or, you know, because you're off lease 500 or 600 feet, right, when you start your well. So you actually go out and obtain subsurface easement to drill that well bore.
If we did not hold any leasehold underneath the surface location.
What if you own 60%? Do you go talk to the 40? Okay. So just if you're not a majority owner in it, then you.
Any ownership. Give
Well,
you the right, wouldn't
yeah,
it?
I mean.
Yeah, I believe any ownership would give you the right to.
Oh, okay. So you have any mineral interest off lease or off spacing unit.
Yes.
then you go ahead and drill. But if you own 0, then you go get a subsurface. Okay. Have you had to do that some? I mean,
Not within our core acreage position, not that I'm aware of.
okay, so I've never heard of it. I was wondering why I'd never heard of it, and that makes sense. If you own, you'd have to own 0 to have to go and obtain that. Okay, because I can imagine that being a nightmare to go find everybody that has a you know, a non-producing wellbore through them to get an easement. And yeah, what do you? Okay.
Hey, Mr. Alder, would you comment on what we just had as a dialogue?
Well, I think it's helpful, and I would appreciate it if maybe as we prepare the findings in this matter and other matters that were clearer. We've used the language that the witness testified to earlier, just the requisite surface and subsurface consent, and it's not clear how that's interpreted by all of the operators. There is a legal argument that if you have the surface rights and don't have the mineral rights, you could still drill through the mineral, and I think that that's not exactly what the board originally intended when that language was added. And so, as I understand the answer to the question from the witness in this case, is that if the minerals are owned by someone else, they'll get the consent of that mineral owner, and I think that's the better approach.
Well, it's the reverse of that. If there's no Newfield ownership in the offsetting minerals.
I need to qualify that, Mr. Chairman. The reason being is Newfields make the decision better safe than sorry. There is case law out there from Texas, very recent case law, that said that if you get surface owner consent, you can do subsurface anyway. So the case law has not been set in Utah. So Newfield is not saying that a surface use agreement legally wouldn't be sufficient by itself, but they take this practice themselves as a precaution. So I don't want it construed as any kind of concession by Newfield that legally they have to go out and do that.
Mr. Chairman, I would like to respond to that by saying that the board can be clear as to what's required, and if the understanding based on the testimony of this hearing is that that's what is going to happen, unless they want to hold out and say that the requisite consent does not mean the consent of the mineral owner and put that in the order, then that's a different thing. But I think the order should be clear so we don't have battles after the fact over what is meant by that language. This is something within the board's jurisdiction to define.
Okay, Mr. McDonald, have you noted that?
It would have been appreciated if this had been briefed out before this hearing by the division, that these were concerns. This is the same language that has been utilized by the board in every single order, creating horizontal 1280 drilling units, and it's a consistent practice. But if this had been an issue, it would have been appreciated to have an opportunity to know in advance and brief it out.
Well, this issue was raised by a letter from Newfield to the board and the division with regard to an axia.
Newfield or axia?
Yeah, with regard to axia. So Newfield knows that this is an issue, and I think that's the reason that there's been a reason for clarification. I don't think it's ever inappropriate to clarify what's intended by an order. I apologize for not having time to put together a memo on this point, but I think it's something this witness can answer and that this case can resolve.
So what's the concern that an operator's going to go and back and perforate in that non-lease area? As a mineral owner, I'm not concerned if you drill on me and, you know, the well bore is on me, but you don't perforate. I mean, we're trusting the oil companies where their well bores are, say they are, is where they are. So
it's actually, you know, self-certification.
So I'm trying to understand who is concerned about a well bore.
Well, the issue is that if you're drilling, if you're also drilling, so if you own the minerals here, but your drilling unit is off and you're going to go through somebody else's minerals, that may prohibit their well bores in that same area.
From getting to that.
Yeah. Anyway, it's just a question as to what is meant by the consent of the subsurface owners.
I mean, I just think it becomes way too cumbersome if you require you know, who you going to ask. Just, I mean, you got to designate what area you're going to ask, and you could have 100 mineral owners, you know, in that. I just think that's overkill by somebody worried about anyway. But if there's legitimate cases like that, is I can see that where, okay, there's a wellbore there, you're preventing me from drilling a vertical well there because, you know, you've got a wellbore going down. But other than that, I don't.
I just think that generally, at least the first time I heard the language and the times that it's been used, it's generally been understood that you will get consent from the person who owns the subsurface.
Well, the problem
rights.
is it's not a person, it's, you
No,
know,
I think
what
that, and
person?
I don't think there's any question about, you don't need everybody. I don't think that's the issue.
Okay.
I think the question is, do you need the consent of someone who has subsurface rights, or do you not?
Okay, so that's consistent. If there is some ownership in that,
Yes, yes.
in that mineral, then you take that as consent. Okay,
And
and I think we can, yeah.
okay, I apologize
Okay, I think-
for the diversion, but I think it's
Well,
an
no, the
important
question is, board members, do you understand the issue now? You know, is there any confusion? And I don't think there is.
So
back
there is
to you.
language in this order about that?
Well,
It's been the language that, as Mr. McDonald pointed out, has been used generally for a couple of years since it became the practice to drill, or to at least request the right to drill off lease. And then we put in the language about the shoe at the bottom so there wouldn't be production outside of the production interval. And then we also added the language about the certification from the surface and subsurface. And that language is just sort of, I mean, other people see the orders that the board's issued that Mr. McDonald's prepared, and then they adopt the same language, and it just is not clear what it means, and that's why I raise the issue.
And if they fail to get it, they expose themselves to issues of trespass or slander of title or something like that. But it's the clear thing is they can't produce from it. So in terms of correlative rights, it's not an issue. But it is an issue in the legal arena, but not necessarily an issue for this board, other than to get consent so that the people know the rules of the game before they play, and that's the issue behind it. Okay, back to you, Mr. Alder. Do you feel like the board understands your point?
Yes, and again, I apologize to Mr. McDonald for intervening with that issue here, but I appreciate the clarification. Just to make sure we're clear, you mentioned the Knowles well, which is on 4 South, 2 West, section 15.
Could you point to that with a marker, please, what we're
right
talking
there,
about?
sir.
Okay. Everybody understand where that is?
Okay. And previously in the prior order, 139, 145, you asked that was really just a request for an exception location for the north and the south extent of that well.
Correct.
There wasn't a spacing request.
No.
And now in this instance, we're also not asking for that well to be spaced on a 640-acre basis. Is that right?
We're asking for a temporary 640-acre spacing for this so we can allocate production across the full section.
So just to be clear, because I think the language in the request says on a wellbore basis, but you're telling us that.
No, it doesn't. It specifically accepts out the Knoll well situation.
It says a special drilling unit. So the special drilling unit would be 640 acres for that well?
For that well, yes.
That's good.
Yes.
I think that's all the questions, Mr. Chairman. Let me see if the division has any. Could Mr. Rogers, with the board's permission, ask a question of the witness?
Yes, proceed, Mr. Rogers.
Yeah, just for clarification on Exhibit G. You have outlined as in the blue as the Mighton buffer. Why to the south is it only notified to about a quarter section? To the north, it's up 2 total sections.
Because to the south, it's not spaced. The north is the 139, 134 spacing that we got in 2015.
Okay. I just was wondering about that. Thanks.
All right.
Board members, any questions of this witness?
Just one quick clarification. So if there were a vertical well proposed, did you say that this order specifies that there would have to be approval of the board? Or how did you, or is that not quite correct?
The order, if it's granted, would allow up to 8 vertical wells in the 1280.
Okay, period.
Yes, and that was
Can just be
intended,
drilled.
that was
Okay.
as a result of the 139, 134 order and the division's request for flexibility.
Okay, but
And
it's,
then a 9th well would have to come back to the board.
okay.
Right.
But it's not Newfield's intent to drill any vertical wells
Correct.
in the foreseeable future. That's correct, okay.
Yes.
Other questions, board members? Seeing none, then back to you, Mr. McDonald. Call your next witness.
Riley?
Welcome to your first time before this board. Is Mr. Brinkerhoff?
Yes.
Welcome.
Okay, Mr. Brinkerhoff, would you please state your name and business record or address for the record, please?
Yes, Riley Brinkerhoff. I'm at Newfield at 24 Waterway Avenue, Suite 900, The Woodlands, Texas, 77380.
And what is your current position with Newfield?
I'm a staff geologist.
And do you have responsibility over the Mighton area that we're talking about today?
That's correct.
Okay, would you briefly outline for the board your education, work experience, particularly with the Uintah Basin, any licensures that you have, and if you've been qualified in front of any other commissions?
Yes, I was born and raised in Uintah Basin, graduate high school out there, came out to BYU where I got my bachelor's and master's in geology, went ahead and got an MBA at University of Utah. I worked for Questar out working the Uintah Basin and similar basins in Wyoming, Colorado. I also worked for a calcite mine above Hanna, so I worked a lot of stuff out there, know that area quite well, and then I've worked for Newfield for the past year and a half working the Uintah Basin.
And are you a licensed professional geologist with the state of Utah?
I am. Passed the ASBOG back in 2010 and been licensed in the state of Utah as a professional geologist since then.
With that qualification, Mr. Chairman, and presuming if the division has no objection, I would ask that the board recognize Mr. Brinkerhoff as an expert in geology.
Mr. Alder, division.
No objection.
Board members? Okay, he will be admitted as an expert in geology.
Mr. Brinkerhoff, I'm going to show you what have been marked as exhibits H through K for purposes of this cause. Do you recognize these exhibits?
Yes, I just prepared these for this action.
Okay. Turning your attention to Exhibit H, which is shown on the PowerPoint, would you please explain to the board what this represents?
Yeah, this is a stratigraphic log from the Brotherson, the Shell Brotherson 111B 4 well. It comes from, it shows the transitional Lower Green River and Upper Wasatch Formations, and was used because it is the same log we used for the 13990 and 139-134 orders.
And this also reflects the primary zones or targeted zones that Newfield is seeking to produce from in the Mighton area?
That is correct.
All right. Turning your attention now to Exhibit I, would you please explain to the board what this represents?
So this is a log from the application area. It's the Ute Tribal 10742. It shows the main intervals that we plan to target horizontally in this area.
Right, and this is also just correlate with the prior log as well, right? It's a correlative log.
So they're, of course, are correlated. We'd like to show you exactly what it looks like in these areas.
Okay, now turning your attention to Exhibit J, please explain to the board what this represents.
So this is a cross-section from west to east, both in the application lands and in the previous order to the north, to show the continuity of the formations and their applicability to long horizontal drilling, both that we're just extending from the north to this Mighton area, and that it's ideal for the type of development we plan to do here.
All right, turning your attention now to Exhibit K, please explain to the board what this represents.
So here I am showing one microseismic and then other stress indicators that come from image logs to give us an idea of what the in situ stress is in this area and how it lends itself to stand up spacing units. This shows an average stress and fracture orientation of north 79 degrees west, and that stand up is the ideal way we'd like to space this.
Okay, in your expert opinion, then, is the uniformity and thickness, does that make the Lower Green River-Wasatch an attractive target for longer lateral horizontal drilling?
Yes.
Is it also your expert opinion that the fracture orientation supports stand-up drilling units?
Yes.
Finally, is it your expert opinion that the Lower Green River-Wasatch constitutes one common source of supply?
Yes.
That concludes my examination, Mr. Brinkerhoff.
Mr. Alder in the division.
Thank you. Mr. Brinkerhoff, in the request for agency action, it talks about, it quotes from the 139-134 order. Did you work for Newfield at that time?
No.
Are you familiar with that order?
Yes.
Paragraph E that's included in the request for agency action in the findings of fact number 9 of that order talks about it's difficult to establish, difficult if not impossible to establish uniform setbacks between SXL wells and vertical or directional wells, and it says yet both may be required to maximize resource recovery. Are you familiar with the decision as to whether to use horizontal or vertical wells to maximize resource recovery?
In this question, I'd like to defer to Mike Jensen.
Okay. Reading on, it talks about vertical wells may be required to recover resources from intervals above the PAR-F interval and below the upper Wasatch interval. Can you refer to maybe exhibit, your type log exhibit H, and tell me what intervals those are?
Sorry, so the question is which intervals are above the...
What are the resources above the bar F interval and below the upper Wasatch interval that are being referred to in that?
Yeah, so the bar F would be the Castle Peak.
Let's make sure the board knows where you are. Could you use
actually, do you mind if we use the, so of course this is the Brotherson log. Let's go ahead to the next exhibit.
Yeah.
Let's go.
Which would be more applicable to this area. All right.
So this is Exhibit I.
Exhibit I, correct.
Okay.
So the bar F was used by the geologists in that application to refer to the Castle Peak. Now we're using nomenclature that has been common in recent boards, so applications.
Can you use the mouse pointer?
So rather than
using
using bar F, we've used standard nomenclature that all operators are using out here as they space these. So Castle Peak, the bar F interval that they referenced would be just this interval here, actually quite a narrow interval. We're including that for the Castle Peak.
So that's the area just below the blue line that shows the Castle Peak.
That's correct. That first bench, that's actually a limestone. That's not the bar F. The bar F would be thinner interval even still. So it's quite a narrow definition. We're broadening that out, of course, as we get further in development and exploration of this area. The areas above that, of course, would be this carbonate marker and Douglas Creek areas, which you see here and here.
And the here and here is what, the Douglas Creek and the
Douglas Creek interval and the carbonate marker interval.
So is it correct to interpret the finding of fact that's included when I just read to say that vertical wells may be necessary to recover resources from the Douglas Creek and carbonate marker as shown on Exhibit I?
Currently, we have no plans to drill vertical wells. These have been targeted horizontally in the basin, and we would plan to also target them in these areas.
With horizontal wells?
Correct.
But the language that's referred to that's how it's meant, is to refer to the Douglas Creek and the carbonate marker. Those would be the intervals above the bar F interval. Is that not correct, what you just said?
Correct that they are above the bar F, but we would not plan to go after them vertically.
Are there other resources above there that you might go after with a vertical well?
The shallower you get, the less potential they have, but there is potential in the Garden Gulch, which you see here, and perhaps even above that, but they're deemed of lesser importance.
And then as to the language about below the upper Wasatch interval, what referring to Exhibit I, how are those formations denoted?
So the upper Wasatch we like because it's very similar to some of the other intervals that we're currently targeting. The lower Wasatch in this area has few penetrations. It's a more of an unknown exploration target, and while we would also view it as a horizontal target, it's much more of an unknown and would need to be explored.
So the request is asking for permission to drill 8 horizontal wells per formation. It's not specific as to what the 5 formations are. Can you identify what the 5 formations are as you understand the request? 8
wells per formation? 8 vertical wells per formation?
No, not vertical, excuse me, horizontal.
Oh, okay.
Yes, okay.
So
ask your question so that we're clear for the record.
Sure, if I misspoke, I apologize. The question is, the request for agency action asks the board to allow 8 wells, horizontal wells. I interpret that to mean short or long horizontal wells per formation, and indicates there are 5 formations. Could you identify what those 5 formations are that you are asking the board to allow you to drill the 8 wells in?
The 5 that we're talking about, of course, Douglas Creek, the Carbonate Marker, Castle Peak, Ulan Butte, and Upper Wasatch.
And so for each of those formations, you would be allowed by the order to drill 8 wells. Would you not, then you would have to come back and get a modification to the order to drill into the Garden Gulch or the lower middle Wasatch, I guess that's called. Is that middle?
No, we would not want to be held to that.
What do you mean you would not want to be held to that?
We're asking for up to 40 wells, and that would leave us, of course, additional wells to target other intervals. Or, for example, if some of these other intervals, which are very thick, may have what we'd call stack potential, we'd want to drill perhaps above them.
So you might drill 16 wells in the Carbonate or the Douglas Creek?
Correct, but they would not all be at the same TVD.
TBD.
A TVD, a true vertical depth. We would be going after a stacked interval stratigraphically higher or lower.
All right, so the order should be clear that you're asking for 40 horizontal wells in the Lower Green River at formations to be determined.
That would be correct.
Just one second, Mr. Chairman.
Okay.
I think that's all for this witness. Thank you. Unless the division has a... Mr. Rogers, Associate Director, has a question or two, if you could.
Proceed.
Yeah, I'm looking at Exhibit I. Oh, not I. That's different than this. Okay, maybe not. Okay. As you go through and you do a horizontal, you pick one of these to do a horizontal zone, it's quite narrow, isn't it? What, maybe 100 feet above, 100 feet below, you have the frac effect?
It actually, as we model these, varies widely, depending on the lithology and what we call barrier units that can make that more narrow, or the lack of these barrier units, they could be higher and lower.
So, but the whole thickness, I'm looking from the top of what you have in green here is approximately 1,800 feet of rock.
Yes.
Obviously, you're not perfing all that. You're just perfing the isolated zones. Is there any benefit to offsetting and put in a vertical well far enough away where you could get the rest of the production within those areas if you're leaving that behind?
We are not considering that. The economics would not support that based on our current operations.
So haven't other vertical wells been successful in this area?
That's proprietary.
Okay. I guess a concern I have is we allow this large area essentially only for horizontal wells. That's what you plan to do. I know we're allowing possibly 8 per there, but if you get enough horizontal wells in there, you may not be able to fit in vertical wells after the horizontals are drilled. And I'm concerned that you're leaving some reserve behind that could be brought up with a vertical program if it's not planned out enough or have.
As an interest owner here, we are trying to most efficiently recover and prevent waste. We want to recover the resources. The problem with the vertical is that it actually promotes waste, as we are recovering much less. You put a couple verticals and have to space or offset off of those. That is actually a much larger area that we would be not recovering the resource.
Do you have somewhere in this where how far you could offset from a horizontal well with a vertical where there wouldn't be interference?
It would be very widely, depending on the zone in question, as the lithology and the quality of the rock or the reservoir makes that very distinct. It wouldn't be a uniform number going up and down the wellbore.
So I noticed in your request for agency action, you mentioned the Uteland Butte about 200 feet. So depending on which rock formation, it's going to vary how widely?
As far as drainage offset or
frac length.
We have seen a huge difference. Also has much to do with because we have a lot of faulting and natural fracturing, which is very difficult to predict. So some areas we see large offsets, and some areas we don't, and so it's very difficult to put a uniform number to any of that. 200 feet is not a bad number, but it's not anything we'd want to be held to.
Okay. So if you feel that there's not the potential here, why are you asking for possibility of vertical wells in this area then in the future?
So it's a very thick interval. We would like to be able to explore things as cheaply as possible as new development concepts come up. It's very expensive to try to explore a new concept with a 2-mile-long lateral, or, for example, perhaps we want core, and with that core we'd want to do a small test of an interval. It's for the flexibility to be able to have an exploration program that would continue to go on with a development program.
So the vertical well be more of a research stratigraphic study rather than an actual production well?
As we currently countenance, yes.
Okay, thank you.
Board members, any questions? Mr. Moon.
I recognize him now.
Yeah.
Knew him 10 years ago.
Yeah.
So looking at this exhibit, there's those two 1280s that drop back down below the line of 280s.
Yes.
So just using them as an example, there's wells toward the south end of there. How deep are those wells going down into the Wasatch, or are they just Green River wells?
They are variable, but as a rule, most of them went to the base of the Uteland Butte, some a little bit further. By and large, though, the development scheme at the time when those were drilled was just to hit the sands. So, for example, they do not have completions for the most part in the carbonate units, which would include the Lower Castle Peak, the Uteland Butte, and the Wasatch carbonates.
So the horizontal wells you're planning on doing here, which ones do you think of? My question really is, how are you planning to drill around those existing vertical wells? Use setbacks and.
So we have not formalized plans on those. In Central Basin, where we have been developing, we do not have a standard setback off those vertical wells. We more plan it on a long-range DSU holistic plan to, yeah, sorry about that. Usually I'm very loud, so you guys got me all intimidated. So we would be trying to plan on the entire drilling unit rather than the just for what the best spacing would be at that vertical well, because we, of course, would want to put many wells into that drilling unit. As far as that particular case with those wells on the south end of those DSUs, we would have to look at which wells are completed in which intervals that we are targeting horizontally. However, I suspect that it would be more similar to what we are spacing that same unit, for example, like the Uteland Butte, everywhere else, as we've determined the ideal spacing to be.
Okay. Is those over toward the east side of the unit? There's a lot of vertical wells there, but you still see plenty of horizontal
potential. Yes.
Potential
For
there,
example,
even though like section 2 and 11, 3 and 10, there's 16, 18 wells in those.
Right, and the scheme when those wells were developed, remember this is a tremendously thick oil saturated interval. The scheme that they were using at that time was by and large to go after just the sands. Right now, the two wells that have been drilled horizontally in this area are both Uteland Butte. For example, if we were to drill Uteland Butte in that area, it'd be by and large still a virgin reservoir.
Okay. So when you say sands, that's mostly Castle Peak?
Castle Peak, Douglas Creek, sands clear up into the Garden Gulch.
Okay. So and then the Uteland Butte becomes more
it's still carbonate.
Shale or?
No, it's a limestone and dolomite.
Okay. 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 Thank you.
Other questions? I have a couple. First question has to do with, is there any geology out here that would prevent you from drilling the full length of a 1280 within the setbacks? Specifically, is there any faulting or?
This is in the Duchesne fault zone area. However, there's not large vertical offsets. And we've drilled across the fault zone before. And by fault zone, we're not meaning one large fault. It's a series, a large number of small faults.
But the offset is manageable.
It's manageable, and we have not had that. For example, the well that we just drilled that we're asking for relief on the knoll, that well crossed the zone and did not have any issues that we encountered.
Okay. Second question, were you in the room this morning when I asked the division to give us some lessons learned on the pilot projects we have?
Yes.
Question I have for you is, speaking only about non-proprietary, what lessons have you learned? NEWFIELD was one of the first and the most involved in our 7 pilot projects. From those first 1280 horizontal wells, long laterals, what are you learning about the drilling part of it? And second, what are you learning about it in terms of geology from those earlier wells? To the extent you recognizing you've only worked for NEWFIELD for 1.5 years, but we're relying upon your basin experience.
Geologically speaking, we've learned that actually drilling out here is quite forgiving as compared to other basins where we have operations or the industry's operations. Horizontally, we have a lot of confidence in drilling these wells. We don't have a lot of the operational issues as far as wells coming in on us or getting stuck. So we have widened up our drilling windows and are able to drill them quite quickly, which has been good. We've learned also the importance of understanding the fracture networks, and that's a research in place as it seems to have a big impact on production.
Okay, thank you. Back for
one more quick question.
Oh,
so what makes you confident that 2-mile horizontals will work in this area? Is that based on Central Basin experience? and these couple of horizontal wells, that you feel confident that 2 mile horizontals will be?
Yeah, we have wells that are nearby,
Yeah.
just a mile up, that worked very well. We drilled that knoll last year before we applied to have these spaced as a test as well, as an economic and a technical test, to be able to show that we could do it economically.
Do you expect these wells to come in as good as the ones up north?
We definitely expect them to be economic. There will be differences just as we're coming south, but we expect them to be strong wells.
Good.
Just follow up on your last statement. You expect them to be economic. Is it an increasing from what was just experienced north of that, or are you starting to see some sort of a decline in the rate of return and things like that?
Yeah, I'll defer that to Mike.
Okay. And Mike, be prepared for that question. Okay. Any re-examination?
No.
All right. Mr. Alder asked you some questions about the 139, 134, and the differences in this request and that. Would Newfield possibly come back and seek modification of the 139, 140, or 134 order to address these additional zones that could be explored based on what the experience you're having?
Yeah, so the technology is moving very quickly on this, as is our understanding of the interval. So, of course, in that original request, we asked for 17 wells. If we were to do that request today, it would be with the 40 wells we're requesting here. We have much more confidence in these intervals now and in our ability to execute.
That concludes my examination, or
Thank you.
redirect, excuse me.
Call your next witness.
All right, Mr. Jensen, would you please state your name and business address for the record?
My name is Mike Jensen. My address is 2001 Lincoln Street, Denver, Colorado, 80202. And my position is I'm a retired engineering advisor with Newfield, work in the Uintah area for 12 years. And I'm now serving as an independent contract petroleum engineering consultant for Newfield.
Mr. Jensen, I'm going to show you what have been marked as exhibits L through N for purposes of this cause. Do you recognize these exhibits?
Yes, I do.
Were they prepared by you or Newfield personnel with your review and input?
Yes, they were.
Turning your attention to exhibit L, would you please explain to the board what it represents?
Exhibit L is a table showing 1,280 acre original oil in place, EUR, and recovery factors for all the zones that Riley just went over. Those 5 main target intervals. So we show in the table the usual parameters: feet, porosity, oil saturation, formation volume factor over 1,280 acres to arrive at original oil in place. So you see what the original oil in place in million barrels is for each one of those zones. The number of maximum wells that we plan with our RAA is 8 maximum wells. We're estimating, I've got a single exhibit.
And while you're on that exhibit, can I just ask you to define the term SXL?
Super, it's a Newfield term, super extended lateral is what the SXL stands.
And does that mean 2 miles?
It does.
Thank you.
I always think it's short. back to, so 8 wells per 1280 per zone. And I've got an exhibit that shows the individual EUR per well that I'll get to in a little bit, but it's actually 582 MBO. So if you take 582 times 8, that's where we come up with the 4.7 million for 8 wells in that zone. So that's the EUR per zone. And then on the far right-hand column, we show the recovery factor varying between 4 to 10%. Below the second part of the little table is the 8XL, or that's would define short lateral.
1 mile.
1 mile, or vertical wells. That's what we're requesting in the RAA. Go through the same EUR calculation. We used the higher recovery, which is the XL wells, to get a total of 2.7 million barrels. We don't know where we'll be putting those, but that would only be 0.9% recovery factor on that full 5 zones section of original oil in place. And so the takeaway from this slide is the red box in the lower right-hand corner. When you add up the recovery factor from the 40 SXL wells and the 8 XL wells, you come up with a total recovery factor of 8.8%, which is less than kind of the standard that's we've used and other companies have used of 10% recovery factor to justify the extra wells that we're counting on versus the 139, 134 order, which was 17. So just a little more detail on that, because that's an important fact. And 17 wells, the thing that's changed from 139, 134, we've added 2 zones. Riley went into that a little bit, the Douglas Creek and the carbonate marker. We've, from our 139, 134, those zones were not included. So we went from 3 zones that were included in that 139, 134 to 5 zones. We've also have some small changes to the petrophysical model, which has added a little more oil in place. So we're actually showing about twice as much oil in place, but we've got almost twice as much thickness for starters that we are showing here versus the 139, 134 order. The other factor, so that would get you from, let's say, twice oil in place, it get you to 34 wells. We also have a little bit less EUR of 582 per well versus what we showed in 139, 134, which was 650 average EUR. So you're able to fit in more wells at still a low recovery factor. So double the oil in place, a little bit lower EUR per well, that gets you from the 17 to the 40 wells that we're asking for, and also including the 8 XL or vertical wells, still under a 10% kind of benchmark recovery factor. That's the only takeaways from this slide.
Okay, turning your attention now to Exhibit M, please explain to the board what this represents.
Exhibit M is just a quick box showing the individual XL well economics, parameters, and estimated results. Like it says, it wasn't as clear, but here for an individual well, you can see we're listing the 582 MBO that I referenced in the last slide. Well cost of $7 million is what we're estimating. Of course, there's associated gas, which gets you up to 780 MBOE equivalent barrels. Standard working interest. Oil price we're using in this example when we put these slides together, and also what NEWFIELD is using for their scoping budget for 2018 is a $50 oil price. Of course, that varies all the time and has varied a lot recently, up over $64 per barrel, excuse me. So that does vary, but that's what we use, and it's a good benchmark and good long-term look at it. Gas price of $3 per MMBTU. rate of return of 22% and a payout of 3.5 years. So takeaway from this slide is we see these as being economic in this area that we're applying for at a 22% rate of return with possible oil price upside.
Okay, now turning your attention to Exhibit N, would you please explain to the board what this represents?
Exhibit N is a exhibit that you've seen many times from Newfield and other operators. It's a horizontal well setback illustration where, of course, the horizontal lateral is shown in red. We're estimating the orientation of the fracs on the toe in to be north 79 degrees west, which Riley went over in his, that orientation comes from his Rose diagram exhibit. These are the same frac lengths for the Wasatch, average effective half frac lengths that we've used in 139, 134, which are, the longest is the 334 in the Wasatch. And assuming the longer half length on the east-west side, we're still showing a good buffer of 232 feet before you get to the section line. And that's at a 560-foot setback on the east-west side. And then on the south side, we're showing a good buffer of 266 feet from the end of that frac to the south section line, which gives a good buffer on that side. So as shown, the reduced setbacks will not adversely affect relative rights, in our opinion, on the adjacent drilling units. But they are aggressive enough, 330, that's the exception we're asking for in this case, to go from 660 to 330 and then 560. They're aggressive enough where we feel that they'll protect relative rights, but still prevent waste and gives us an aggressive look at it.
Okay, as you're aware, some of the other operators have requested and the board has granted orders providing for overlapping drilling units for vertical and short lateral wells, whether it be 40 or 640, depending on spacing, and the 1280s. And even though it was untimely filed, EP raises the same issue, so it's important for Newfield to justify why it requests the conversion rather than the overlap. So would you please address that to the board?
And bear with me a little bit. It's just a narrative of why convert to 1280s. So it's Newfield's view on this particular matter, why we are for converting to 1280s instead of the overlapping drilling units. So I'll kind of go through our some of the main points and main reasoning.
And then make sure for the record, the kind of the definition of terms at the beginning of what an overlapping means as compared to a conversion.
Yeah, the best way I can term it with my understanding from the other cases, overlapping would be you would have different spacing units within the same larger, I think in all the cases it's been 1280 areas for vertical short horizontal wells and 1280 wells, which the short lateral wells would be a 640 spacing unit, and the vertical wells, depending on which cause, sometimes it'll be 40 acres and sometimes it's 640 acres. And then the long lateral wells would be spaced on 1280. So you have actually potentially three different spacing units. So they all overlap each other in the big 1280 unit itself, and there could be different, and usually are different interests in each one of those wells. So that's how we see the overlapping spacing units. And on the standard 1280 that we're kind of calling converted to 1280 units, it's common ownership across the full 1280 from the date of first production of the first SXL wells. So it converts to a 1280 unit where there's common ownership across the whole area, the whole 1280 DSU. Is that how you understand it, sir?
Yeah, I just want to make sure that everyone's on the same page in terms of that. Board members, did everybody understand that the same way? Okay, thank you.
So again, I'm just going to do a little bit of narrative on why in this particular application we believe converting to a standard 1280 is the way to go, which again, we're extending from our Central Basin 139, 134 that we've been operating under for 2.5 years. It's been working well. It's almost getting to your point, Mr. Chairman, of some learnings. NEWFIELD likes that type of scenario. It allows a lot of flexibility and some other points I'll make right here, but I just wanted to bring up that is some of the learnings ahead of time. So why convert to 1280s? Consistent and uniform stand-up 1,280-acre drilling units will dramatically facilitate flexibility and planning of multi-well pads, production facilities, and infrastructure pipeline corridors, which improves economics and reduces surface disturbance, infrastructure duplication, and traffic. We can do all those things because you have common ownership, common tank batteries, common pads, where everybody has the same interest. Different interests in wells in an overlapping scenario, an overlapping DSU does not provide this great of a cost advantages. Second point, a common interest 1,280-acre DSU will provide flexibility in locating the maximum amount of efficient SXL wells. Overlapping DSUs would cause waste by limiting the number of SXL wells due to the setbacks necessary to prevent communication with vertical wells. Board Member Moon, you got into that just a little bit when you were asking where you're going to put these wells when you have existing vertical wells. It does become a problem, especially in an overlapping scenario where you have setback requirements. It limits the number of wells, and I estimate limiting the number of those XL wells from 25 to 60% less XL wells in that particular zone, because you already have vertical wells that you would have to stay away from. We see that as it could be a possible negative in an overlapping scenario, resulting in unrecovered resource. Again, in 139, 134, NEWFIELD likes where everybody's interest is the same, and you're not as concerned about staying at a setback away. Yes, you may stay away from the vertical well for other drainage reasons, but it's your choice. It's not the choice of worrying about interference. So the next point is a little bit longer, but it has to do with some of the setbacks, and I think some of the quotes you referred to, Mr. Alder, in 139, 134. It's difficult. We definitely agree, particularly early in the life of a play, to establish uniform setbacks between long lateral wells and vertical or directionally drilled wells. Variables such as permeability, that came up in some of the previous testimony today, where lower permeability, you're not as worried about interference possibly. So there is a difference in permeability from zone to zone, and we're spacing a fairly large interval. The other thing that sometimes it just takes time to see if there's interference between wells. So that's why I highlighted early in the play, it's much more difficult because you just haven't seen the interference that in tighter formations sometimes takes years to see the interference, and you don't know that for some time. No data that I have seen has been presented to the board that reflects justification for a 330-foot setback between a horizontal well and vertical well is appropriate to prevent communication. NEWFIELD believes the distance required to best protect relative rights is not known. So we don't come here with the answer that we can tell you what the appropriate setback is. But we could only surmise that in some of the previous cases, that's possibly some of the figures from Exhibit N that I just showed you with the setbacks to the lease boundaries were inadvertently used in other causes for the 330-foot setback justification. And again, Newfield does not know the exact answer. But the one thing we do know, and why we're promoting a full 1280, all of the possible communication and consequential setback issues are eliminated with the proposed conversion method that we're asking for in this particular cause. Since the allocation is on a uniform 1,280 acre basis, and correlative rights are therefore protected, and also waste is minimized. The fourth reason has been brought up many times. For this particular cause, Newfield has a majority interest in the proposed DSUs in this cause, in this area, and has no plans to drill vertical wells, only SXL wells in the application area. Just while I'm at it, I may preempt a question. It's about the 8 short lateral or 8 vertical wells, either or. So we are asking for that. Here I'm just saying we have no intent. Yes, we have no intent. I think those 8 wells, when they were put in 139, 134, and that's what Mr. Alder was reading, it was discussions with the division to have some flexibility, which I like. Newfield likes that flexibility to drill those wells essentially after you've developed it with SXL wells. You'll know so much more about the geology by drilling a lot of horizontal wells. There sure could be areas that are performing very well that you're thinking, well, I can't justify another long lateral well, but I'll drill a vertical well to capture those reserves. Oil price changes could come out. So I think that was the intent. I was, of course, part of 139, 134, and that was the intent of that addition, but it was worked out with the division to allow for that flexibility to capture some of those attic reserves. And yes, in the verbiage, it's also some zones possibly above or below, but they are, highly speculative at this point. But as Riley testified to, that flexibility to drill a vertical for core samples or a short lateral well where you're just kind of testing something new was the other aspect. Those were included. So I just wanted to address those, that reference to 139, 134 and how it applies to here. And again, we're really just extending 139, 134. We like 139, 134. We like the conversion technique, and we just kept that the same because that does give some flexibility, although it's not the intent initially. It's for SX wells. So that kind of hits up the reasons that we like the conversion to a common interest 1280. This is very close to the Central Basin areas. Just a quick extension where it's working well for us, and it does get difficult. I think Mr. Chairman, you brought up you have different geology across the basin, different areas, north to south, east to west, that may allow for vertical wells. It's more prospective for vertical wells. We don't see it in this application today.
Okay, a related issue to this is dealing with the existing wells. And one of the concerns or justifications for overlapping wells is potential dilution of a party who has an interest in an existing well. And in response, you prepared in my office, drafted up a PowerPoint based on your notes of a demonstrative exhibit that the board should have. It was filed last night. You recognize this and you confirm that these are based on your notes and preparation?
I put this together yesterday.
Okay, so showing the first page of the demonstrative exhibit, would you kind of show through the board what happens, what would be necessary to minimize the dilution effect if you do a conversion?
Yes, this was, the question is, as our attorney brought up, the question comes up in a conversion, how many SXL wells are needed to keep a interest owner whole? And so the scenario I threw out is a simplified scenario. When you get into working interests and costs and comparing operating expenses and oil price and rate of return, boy, it gets complicated in a hurry. So this is a very simple, but it made it simple for me to understand. So I apologize ahead of time for the simplicity of this, but hopefully it'll make the point that I'm trying to make of how many wells it will take to keep a royalty interest whole. And I use royalty interest. That's the people that need the most looking out for. So working interest owners can sometimes look out for themselves a little better. So I put together two scenarios. This first slide is scenario number one, and it assumes the worst case for a royalty owner who has only royalty in a 40-acre out of this 1,280-acre unit, and he has no other interest in the 1,280. And again, this is an extreme. All of our current wells have produced a lot of reserves, but this assumes, okay, it's a brand new well. Say somebody went out there and drilled a brand new well, put it on production one day before the long lateral well was drilled. So it's still on a 40-acre basis. I'm not going to get into the wellbore versus 40. The 40-acre is what I assumed. The average EUR of a vertical well we see across this area, it varies across our proposed spacing area, but the average we see is 60 MBO, 60,000 barrel well. And I've already testified and showed exhibits to the average EUR of a S.
How does MBO equal 1,000?
It's maybe it's the M is stands for the 1,000, and maybe
I thought K was 1,000.
I know maybe it's just an oil field. Maybe it's just an oil field.
So what's the acronym? What is M?
M is
M is a million to me. I don't know. Did you say 1,000?
I can't. I don't
Okay.
know. I guess I've been using that for 37 years.
Means 1,000. Got
It does. Yes.
MM would be a million.
But you're right. K also means 1,000 in a lot of times. I guess I don't know the answer to that, but it means 1,000 here. At 60 MBO, we talk in MBOs a lot, but 60,000 barrels is what it means.
Just for the record, it's Roman numeral.
That's what you said.
It's Roman numeral
Oh, is
versus
it? M is a
as
1,000.
compared to script.
Great.
So just following down the sheet, and we'll be able to go faster on the second one because it's just a duplication. So really you're looking at, and again, it's just simplified, just based on reserves, and assuming the royalty interest owner gets all of that 60,000 barrels. So 60,000 barrels versus the number of excess SXL wells times the 40 acres over 1,280 acres. That would be that 40's portion of one SXL well. It would be essentially 1/32. And then the EUR of the long lateral well, 582. So you just work the math through. 60,000 equals the number of long lateral wells times 1/32 times 582. Next line, just multiplying the 1/32 times 582, you get 18.2. And then you just solve algebra, solving for the number of SXL wells that would take to equal 60,000, and it's 3.3 SXL wells. In this extreme case, again, it's doesn't really even apply to the existing wells, the few existing vertical wells we have in these application lands, because they have remaining reserves much less than 60,000 barrels. So this is an extreme case of a full EUR and where you have no other interest except in that vertical well itself. 3.3 wells. So hopefully that gives you a worst case scenario range.
I've got a worst case scenario.
What's that?
It stays on 40 acres and they drill all 31 or, all 16 except for yours, and it stays 0. So yeah, horizontal wells are good for everyone.
And you're really leading into that is the worst case scenario, and we have no plans to drill vertical wells. So it really is a bad scenario.
Right.
Yep. I did want to put the upside to a royalty interest owner would be all 40 long lateral wells get drilled, and you go through the math, and then you're comparing 60 MBO versus 727, so 12 times the amount you're exposed to if all 40 long lateral wells are drilled. Okay, the next, it's just the next exhibit is variation, just going through the math, so it'll be a little quicker on a different scenario, which might be more common. This assumes that you have a revenue interest in the 40-acre well, again, starting from day one, so full EUR, but you also have a revenue interest in 80 other undeveloped acres in the 1280. So if you go through the math, it just changes the fraction. You go from 120 acres over 1,280, which is 3/32 instead of 1/32. So you share in the long lateral wells to a much bigger degree, which is probably more common. And you get 1.1 long lateral well would make you whole if you had some other undeveloped acreage. So that's just kind of a mid case. So worst case scenario and a mid case. And again, a higher case is you could have a lot more undeveloped acreage. But this is significant on the upside to the revenue interest owner in this particular case, 60 MBO versus 2,182 MBO. So 36 times the upside is possible if all 40-acre wells were drilled. That's the only points I wanted to make on those two simplified exhibits. You can get them really complex, but this is the best I could come up with to keep it simple in my mind.
So to just summarize why Newfield believes the conversion's a better way to go, could you just kind of summarize that in a 1 or 2 sentences?
You bet. Newfield is determined and believes the best approach is to again confirm and declare the entire Lower Green River-Wasatch transitional formations as one pool, even though there are several productive intervals within, and have all parties within the 1,280 acres share in production from any well thereon once a long lateral well is drilled. Newfield believes this methodology is the fair and the best method to develop these resources to prevent waste and protect relative rights, both aspects. And again, there's always going to be a waiting game between those two, but we believe in this application area that's the best. Any small changes in the allocation of the existing wells is far outweighed by the allocation and subsequent production upside that I just showed in just 1 to a couple SXL wells, and then also a huge upside of almost 36 times as much.
In your expert opinion, then, are up to 40 long lateral wells plus possibly up to 8 vertical or directional wells per drilling unit, are they needed to efficiently and economically drain the area?
Yes.
Is it also your expert opinion that the required setbacks and conversion should not result in adverse drainage or waste and will be protective of correlative rights by minimizing any impact of communication?
Yes.
Okay, that concludes my examination of Mr. Jensen.
Okay, vision.
Mr. Chairman, Mr. Doucette, the petroleum engineer for the division, would prefer to start asking a few questions if you have no objection to that.
I think any of the people at the desk are approved to ask questions.
I always like to have your permission first. Go ahead.
If you could turn to Exhibit L.
Yes.
So on there, I think obviously you testified where the 4.7 million barrels came from each. That's just demonstrative, obviously. Is that correct? That's correct? For each zone? I mean, each zone is not making 4.7 million on average.
No, that's what we would expect out of 8 long lateral horizontal wells in each zone.
Out of 8, yeah, but they're not all equal, are they? Out of each zone, you're not getting the exact EUR out of every zone that you're developing out here.
We are expecting very similar, so we just, for simplicity's sake, made it rounded to the 582, but very similar to 582 out of the zones that we're modeling from existing wells with new completion techniques.
Okay, so you do expect those to be pretty similar. So that kind of goes to my next question on the 582,000 barrels per well that you've come up with. Where are those wells located, and what formations were they drilled in? A majority of them drilled in one formation versus another, et cetera?
It was a group of 3 wells that these are modeled that were drilled recently, and the rough area, it's in the northern part of Central Basin, so the northern part of 3 south, 2 west, a group of 3 wells. That, of course, we have actual data, and put those in a model, and it's a little bit of reduction in the UR due to pressure. That shows a result of lower pressure is a little bit higher viscosity, so a little bit of a reduction from those wells to the Mighton area. So it is part actual data and part model that we used based on actual data.
So what formations were those 3 wells drilled in? You know,
I believe all Uteland Butte. I'm going to look back just to verify that. Yes, all Uteland Butte.
So are you saying that based off of those 3 wells, you can make a determination that all these would produce similarly?
That is what we're testifying to, that they will be similar.
And is that based off of other experience drilling these wells elsewhere, or is it based off of just these 3 wells, all drilled in Uteland Butte?
We're getting into just a little bit of proprietary information. I'm going to consult just real quick with NEWFIELD real quick and then answer that question. The best I can answer the question after conferring with my client was all 5 of these zones have been tested in the basin. There is not enough data. Some is from other operators. to definitively say that it's going to be similar, but it's our best opinion that it's going to be similar to the Uteland Butte that we're seeing. So they all are productive. What we have seen so far is close to that type of performance, but it is an estimate from all those zones.
Okay, and I don't want to beat this to death, but maybe if you could turn to C1, I just have a question.
Yes.
Kind of shows a bunch of 2-mile laterals there in 3 south, 2 west. I'm assuming these 3 wells were some of those wells, and I guess the question is there a reason you didn't use all of that data?
Yes. Wanted to project the results of a EUR with current completion practices. So completion practices have changed over the time that quite a bit that Newfield has been drilling wells, so horizontal wells. So while it was only just a few of the most recent completions, we felt that was a better base for our model.
Okay. Maybe if we just go back to Exhibit L again really quick.
Yes.
So just on the bottom there, just to clarify, you're not trying to make the case necessarily against vertical wells in this exhibit, are you, or are you trying to do that?
Not at all. This was just trying to model the RAA, which and provide volumetrics to show if all 40 wells that are requested, all 40 long lateral wells that are requested in the RAA, plus the 8 short lateral or vertical wells, if all of those were drilled, that were only at 8.8%. So it's not like we're asking for something unreasonable. So it's not trying to make the case for vertical wells. It was just justifying our request for agency action.
Okay, so if you drilled, in the 2 sections, you'd be allowed up to possibly 32 vertical wells. That would change the numbers for those vertical wells significantly, correct, in that bottom area as far as EUR is concerned for a 1280?
I didn't follow that.
You've got eight wells, that second line from the bottom.
Yes.
You've got 8 wells, and you've got an EUR for 1280. If this was fully developed on vertical wells, that would allow up to potentially 32 wells, and that would change your EUR significantly. Is that correct?
If it was allowed under an overlapping spacing scenario?
Well, just in full development on verticals.
With no horizontal wells?
No horizontals, yeah.
I mean, I can give you it's in our last exhibit, we threw out the 60 MBO estimate.
Yeah,
so
that was the vertical, because this 2.7 is based off of the short laterals, is that correct?
It's based off of 8 short lateral wells, yeah.
So it would just be 4 times that. If it was 32 wells,
Right.
it'd be 4 times the 0.9. It'd be,
Yeah, and again, that's short lateral wells.
And you're saying it's less than that?
You were talking vertical wells, not short lateral wells. So vertical wells, we're looking at more like 60,000 barrels per well, which would be 1.9 million barrels, versus this is showing 2.7 for just 8 short lateral wells.
Okay.
So even less reserves, I guess, under 32 vertical wells.
Okay. If you had turned to Exhibit N. So just so I'm clear on this, I think you testified that the Wasatch was the longest half length that you had. Is that correct?
It is.
So out of all of the zones you're going to penetrate, obviously there could be some differences even within the Wasatch, but based off of your information, that's the greatest, frac half length that you could relatively expect.
Yes, and it's based on these figures were based on microseismic that we only had on the Uintah Butte and the Wasatch. So you are correct. It'll vary itself within the Wasatch, but could vary in other zones, just as these two zones varied.
Oh, so you haven't tested any other zones, and you don't have any other real data on any of the other zones?
Not with modeled microseismic data.
So if you were to go into the Garden Gulch or even the Middle or Lower Wasatch, that could be totally different?
It possibly could.
Okay. Also, I think your testimony, as far as while we're on this, is setbacks from other wells. You're not asking for setbacks from vertical wells. Could there potentially be any issues by getting too close to vertical wells on these long laterals if you get too close?
Yes, you could not get the expected reserves, depend on the distance if you were too close. But this 1280 acre spacing proposal, there's no, everybody has the same ownership, so there's no interest dispute or you interfered with my well. So there's none of that. It would be just possibly you hurt or help the vertical well, and you get less reserves out of the horizontal well.
So as an operator, you wouldn't want to be doing damage to, in the scenario if it was approved, everybody would be sharing, so you wouldn't want to do damage to that other well through a frac hit or something like that that could damage the well. So would you have a internal, are you going to be setting some internal, I guess, setbacks from those wells going forward?
We aren't proposing any at this time in a formal aspect. We like the flexibility to not have to do that. Of course, well collision is another issue that's a major event that we would avoid that. But we haven't sat down and got that close to worry about a collision issue. It really depends on a lot of circumstances. Let's say the vertical well is perfed in the zone you're putting the horizontal well in, but it's not a good looking sand on logs. You're really, and it's commingled with other zones, and you really don't think much has come out of that zone, but you think you can get it in a horizontal basis because north of that vertical well or south of that vertical well is good sand. So you wouldn't mind snuggling up with well collision being the issue. You would feel less concerned about getting closer, and that's the whole purpose of why we like this. Is to have that flexibility to not well collision, but to be able to not have a setback.
But that one vertical would only be draining a portion of what, or the long lateral would only be draining one horizon, where the vertical would be, if you damage that vertical, it could be damaging more production uphole or downhole. Is that correct?
I mean, if it was an actual wellbore damage to the other zones, that would be a little more unlikely to worry about the other intervals. I mean, it's always possible to have a frac hit and have to handle more water for a little bit. If you want to consider that damage where it would restrict production a little bit from the other zones, yes, that's possible. So it just depends on how good a well it is, I think it's already been testified, the existing wells, not counting the spacing units on the east where it's already common ownership, the existing wells, there's really only 6 that are producing, 6 vertical wells, so 16 shut in, so a lot of them are a little bit low on production, so it would be a less concern. But yes, Newfield would factor that in on the distance. I'm not giving you an exact answer because it's a little bit hypothetical.
Right. So your main concern is really right now is collision issues with a little bit of those other issues.
Yeah, if it was good, I hate to just get boxed in that. If it was a real good vertical well, yes, you wouldn't, or maybe you'd skip frac stages near that well. Something like that would be a possibility also. So there's a lot of possibilities.
Okay, and just one other question. I think this was answered earlier, just as far as other operators in the area that you're asking to be spaced. Are there other, operators that are actively drilling in this area that you think possibly would have interest in drilling in this area? Not in the spaced area. I mean, are there other operators that would be interested in drilling in this area that have interest in the spaced interval?
Yes. Discussions with Crescent Point, who's another operator. They have interest in the east, so some of those drilling spacing units that have multiple vertical wells in them to the east, they are an operator. They are not protesting this case. They're a horizontal driller. They've of course been properly notified, so they have no objection to the horizontal development, so they are interested in it.
Okay.
Whether they consent or non-consent each well, I can't predict that. It depends on their own budgets and things like that, but I'd say generally yes.
Okay, that's all the questions I have.
Mr. Jensen, you indicated to the north here you've done the conversion process with another order. What's been the reaction to royalty owners in that situation? Any complaints? Any people feeling that not being treated fairly?
I'm probably not the best one to answer that, but I did have a conversation this morning, so I'm just going to take 5 seconds, and is that all right, to see if somebody else should answer that, or if I can answer.
Let's just have the record. Mr. Chairman, it's 12:15. Do you want to take a short break, or I probably have 15 minutes of questions as well, and I don't know if you want to keep going.
I think I'd like to, unless members, let's just, I'm looking around, keep going.
Okay. Mr. Cook would be the better witness to answer that question.
Yeah, go ahead.
To my knowledge, we have not had anyone complain about the conversion method that we have in the 139, 134 order.
Okay, thanks. I guess Mike's back up. Mr. Jensen, this is a very aggressive approach. As you look at this, you're looking at 40 wells per 1280 times 24. That's a significant, very aggressive plan. We've seen other plans approved here, and we've not seen anything approach that yet. There are well here, well there, but nothing to the level where we're looking at 40 wells per 1280. And so we're looking at this to extremely limiting any kind of vertical production there because it's this aggressive future plans. I wonder if there's any thought to, instead of having the 8 across, to maybe 6 or 5, where you could squeeze in some vertical wells, since I don't know when we'll ever see 40 wells per 1280 in the near future. Would we be all right maybe approving 6 or 5 where we could squeeze some vertical wells in there?
and 6 or 5.
Across, you know, you're asking for 8 across. Could you move that back to a 6 or a 5 so they'd be further apart and you could squeeze a corridor of vertical wells in?
From what we know right now, and it's backed up by the volumetric exhibit, which is Exhibit L.
Okay.
The 40 wells.
What's that new? Okay.
The 40 wells can be justified volumetrically, and Newfield believes that long lateral wells is the way to develop this, and to fully develop it, we feel it could need 40 wells. So to limit it to 5 or 6 across, we feel would limit the potential and cause possible waste.
Okay. So do you see this, if you've approved the 6 wells will be drilled right away, or is it, are you going to drill one in each 1280 down the road, or is it something you're concentrating on one area at a time?
It varies. We have one rig that's drilling in the Central Basin right now. That's when it finishes its well, it's ready to come down and start drilling in this application, assuming that we get board approval. It varies quite a bit on the plans. Sometimes we'll knock out 3 wells from one pad. Sometimes, so it could be 3 wells all of a sudden in one DSU. It could be one, so it depends on several factors, budget constraints, our plans that vary depending on surface pad size, budget concerns. So I'm not answering your question, just saying there's a lot of variables that go into it, and it could be as up to a 4 well pad just right away in one DSU, and then go to the next DSU. But our plans are to come down initially, you know, of course, depending on oil price, but initially with one rig and start drilling in this application area.
Okay.
Right away, yeah.
Well, you mentioned the oil price. That's something that certainly drives this. We've seen it extremely low recently, and it's climbing back up. But our concern would be if you came in, things didn't perform as you had hoped, you drill one horizontal well within a 1280 and decide to move on. That leaves the vertical production there somewhat in question if it would ever happen. And you're asking a large commitment here for all these sections here. So we're wondering, would you ever consider some sort of time frame where if something wasn't done in a period of time that you would revert back to this, to go away, this spacing, if it didn't proceed in the way you have planned?
I think that would complicate the issue. You know, I try to go through a timing scenario in my head that, bottom line, it would seem limiting, and it would be a relatively new type of concept. I mean, exploration agreements, of course, have got timing of drilling wells, so it's not totally out of the realm of oil field type plans, but it would be in this particular area. So I know Newfield would not like to limit that type of timing. There are a lot of different hypothetical scenarios that you can bring up, just like one oil price tanks, but it is one. It would be one 1280. All the rest, that would be unusual. Our plans are to come down here with one rig to start drilling and keep drilling. We've showed, depending on the circumstance, but that even that first well is probably going to keep any mineral interest whole in that DSU with an existing well.
Okay, thank you.
Just as long as we're talking about that concept, let's just follow up. How long does it take Newfield then to drill a long horizontal 1280 well?
I think drill and complete would be and when timing on the completion, when they come in, 30 to 45 days, and I'm going to look back again. Yep.
And how many wells did you drill last year in the Central Basin with the one rig you have?
I'll have to look back for that answer. One I'm prepared to answer is since the 139, 134 order.
Right, it was 2 years ago.
Two and a half.
Yeah.
2.5 years ago. So in the last 2.5 years, I did ask this question, and 30 horizontal wells were drilled during very low oil prices during the last 2.5 years. I can ask if you want.
No, thank you, that's good.
About the last year.
And we're asking for 24 drilling units as part of this request. So would it be fair to say a couple of years before you get one long well in every drilling unit?
It could possibly, if you were just to target one well per drilling unit, which
Right.
It's going to depend on a lot of factors. That probably won't happen. You'll probably, drill 3 or 4 in one drilling unit, move to the next. So that's a hypothetical example that it could take it with one drilling rig, and we're not locked into one drilling rig.
What would entice you to bring more drilling rigs in? Higher price, I guess.
Higher price and good results. We've given you some expected results, better results still. We're refining. We're seeing technology as far as completion techniques. And that would cover a bigger part of NEWFIELD's budget. So it's quite a few factors.
But your current plan is to bring one rig down and drill into this spacing area if it's approved?
Initially, yes.
And so from the concept of fully drilling this out, it would be, according to my calculations, 40 times 2 years to get 40 wells, all 960 wells drilled out. It would be about 80 years to drill out the whole well with one drilling rig. That's just my own calculations, and I may be wrong. It's a long time, you agree?
Well, how about we've got 10 rigs working in, so I guess
10 rigs would be a big difference, but you don't have perspectives.
How long did you say, 80 years? So it'd be...
Well, you said 2 years. If it takes 2 years.
Long.
If it takes 2 years to get one well in every drilling unit, and we're going to have 40 wells
We're glad they're here drilling with their one rig, and we hope for more.
And a good point, Mr. Moon. But the question is, what if you drill one well in one drilling unit, and going to your hypothetical, then you've recovered 1/3 of the well that might have been recovered from drilling that vertical well. Isn't that true? So somebody spent $4 million to drill a vertical well. I don't know if that's accurate, or $2 million. And they anticipate their recovery from the oil that we produce from that well. But if you drilled and converted that well into a 1280, as I understand Exhibit L, that shows that it would take, or not Exhibit L, your demonstrative discussion, it would only recover 1/3. It'd take what was it? Yeah, take 3.3 wells to recover the cost, and if they just drill one and stop or go somewhere else, then they've only recovered 1/3 of their costs. So my question is, wouldn't that discourage other people from drilling vertical wells?
You're using the, I put together that exhibit yesterday to help answer some questions and just educate us all. It was educational for me. It is a worst case scenario. I prefaced that when I showed it.
Right, I understand that, but
Okay.
it could happen, and certainly as to after this order's signed, and they're subject to the notice that if they go out to drill a new well, someone could come and drill a 1280 on top of them. It's going to figure into their calculations, wouldn't you agree?
It could. I'll go back to It is not Newfield's intent, who has a controlling interest, to drill any vertical wells, so that scenario wouldn't even happen.
Granted. I guess the question is, what is the disadvantage to Newfield of overlapping drilling units? What are the problems that you see to, because wouldn't it make sense in some instances to have the flexibility to drill short horizontal or vertical wells in an area like you have done on the east side of your spaced lands?
And again, I testified to what I thought were the advantages and why we were proposing this. So there's several reasons. I can go back through them.
No, I don't want to go through the advantages. What are the disadvantages?
Which included disadvantages.
Maybe I missed.
It doesn't promote common tank batteries, common pads was the first point, because you have different interests. You could have waste because you got to stay so far away from the vertical wells that you're not able to develop it like Newfield sees fit with horizontal wells. So that's a disadvantage, so economic waste, resource waste, the potential correlative rights issue.
Explain that.
Interference between different interests in a horizontal versus vertical well.
Okay.
And I guess I'll leave it at that. But that is an issue. So those are three.
Mr. Alder, how much more do you have of this? Some of this has been asked and answered. There's the only reason
I hate it when you say that, Mr. Chairman. Because I didn't think it had been answered.
Okay.
I'll finish.
All right.
I know it was a long narrative when I did that, and I'll just finish up this with one more point. It may not be a disadvantage, but you've got an operator, Newfield, ready to get after it. We've done this type of scenario in the North and Central Basin, and it's worked well for Newfield. We like it. No major complaints. We're not stepping away 50 miles. We're adding on this particular to the 139, 134 order. So that's how I'd summarize it.
All right, and yet, wouldn't you agree that it's a difficult question to the extent that there are potential problems of vertical well owners, as expressed by EP in their letter, not being diluted if they have started a vertical well or have a fairly new vertical well, and then this spacing gets converted to 1280. Now their projections, whatever they were, are no longer valid, and they have to depend on at least three long horizontal wells being developed to recover their costs. So isn't that a disadvantage that could be avoided by having overlapping spacing?
There is no perfect scenario, and I'm going to agree with you that that's a possible disadvantage in the extreme case. In the extreme case that I've tried to.
Why is it so extreme? Because it's certainly
because
possible.
it's a existing well right from the beginning, where you just have interest in that well only, and no other 40-acre within that 1,280-acre unit.
All right.
So those, to me,
those hypothetical situations probably don't exist. Okay.
Yes. I guess that's why I'm bringing it up. But yes, that's always a possibility. But throughout my testimony and Newfield's actions, we believe that the advantages far outweigh possible hypothetical disadvantages that are smaller on nature when you're looking at the reserves that are recovered by horizontal wells.
Okay. I want to yield to the chairman's concern that we move on, but I'm a little unclear still as to exactly the nature of this request. So prior to, and indulge me with a hypothetical, prior to a 1280, and I really wish you'd change the term SX well, because that sounds like short horizontal well to me. But, but prior to a long horizontal well being put in, what are the limitations that the division could look to preclude approving an APD for a vertical well in a unit, since the 1280 isn't going to take effect until the month after the first production from the first long? How does the division determine approval and spacing for vertical well applications to come in?
I guess testimony in our RA, it does stay at the status quo until the first SXL is drilled. So,
and the status quo is unspaced.
yes, I'm not going to go down that road, but yes, I'm going to agree with that. I think I'm answering your question, but I'm not.
Yes.
Okay.
But under the unspaced, under a rule, unspaced land could have 32 wells as opposed to 16 per drilling unit. So how do you determine the locations of those wells?
If it's up to NEWFIELD that has a controlling interest, we don't even apply.
I also believe Mr. Cook's testimony is that if any of those were done, then NEWFIELD would object to those kind of petitions.
Well, I don't believe there's an objection procedure in APD approvals.
Well, there are, but we can argue that on a legal basis later.
I mean, after it's approved, you can come in and object to the approval. But do we really want to go down that road?
But what is the scenario that would happen? If the order's already in place and people know what the rules are that it would be converted, who would be filing for the vertical wells? If NEWFIELD is particularly the working interest.
Well, if NEWFIELD owned all of the mineral interests, there would be no reason to even have it.
So here's the scenario.
Gordon, hang on. You haven't been recognized yet. You haven't been recognized yet. Okay.
My apologies.
No, it's the dialogue was between the two. We'll let you ask your question, but I'm not going to have three-way conversation going on here. So, okay, we're back to you to answer the question that was proposed, if there is still an answer left to be made.
There's some legal questions involved in that, and what the division's saying. The division, if they want to approve it, that's fine. There's appeal procedures, but there's practical considerations that have already been testified to that NEWFIELD would object to that. Number two, as a working interest owner, if this order is in place, anybody who's filing for a vertical well takes the risk that it could be converted once a long lateral well is in there. The other thing is, the testimony has already shown, is NEWFIELD is the working interest owner, majority owner in all of these lands, and who's going to propose and who's going to drill the well without the majority owner's view. The other problem is, as Mike testified to, the infrastructure. Do you want to have 32 separate well pads out there instead of combined well pads for horizontal wells? That it goes to the infrastructure issues. So, I mean, while it's nice to talk about that in a hypothetical scenario, the reality of it is that probably is never going to occur.
Mr. Moon, you had, now at this point.
Yeah, we hope that doesn't ever occur. We believe, based on NEWFIELD's testimony, horizontal wells are going to work, or they're going to be more productive, better for everyone. But a scenario that could happen is a few horizontals are drilled, because correct me if I'm wrong, but your 40-acre vertical wells have been economic wells. They've been good wells. Okay wells. There's a lot of them down there. So anyway, they were the way to go for a while. Now we're saying horizontal is the way to go. So I think the division's concern is, what if something changed and we wanted to go back to vertical? I think a simple solution to this is just to make it up to 32 vertical wells. Now, we don't think that's ever going to happen, but if it did, we would be back to the status quo, which is basically where we're saying we are anyway until a long lateral is drilled. and producing. So that's just a thought I had. Just make it 32. They were basically status quo. If there's ever a change, if Newfield decides to, try some verticals before the long horizontal is drilled, they're status quo. They're shared on a 40-acre basis. It does confuse the issue to go to 8 vertical wells, because that sounds like EP's area. I mean, that sounds like a different up north, because that's the way it was up north. 4 wells per 640. It sounds like we're kind of straddling a fence there. Why not just say 32 vertical wells can be drilled? Now, we don't think we're going to be. You don't want to, but if it ever happens, that leaves the flexibility there, and it answers the questions about setbacks and everything, because you're under the a 40-acre vertical drill, or if you do a short horizontal, you're a 640 spaced until there's a long horizontal drill. So anyway, that's my thought. And then as far as the the 5-year window, well, we'll go to that later. Anyway, that's just on that. That would be an idea to resolve that.
As to just ask your thoughts on the 640 wells, then under the general siting rule, there's only one short horizontal well allowed per 640 until there's a drilling unit. And I know from the prior testimony in Newfield that they think the long are better than the short, and that certainly is what everybody hopes. But does the order intend to preclude other horizontal wells, 640-acre horizontal wells, until there's a 1280?
Does that need determined? I doubt they'd be wanting 2 short horizontals, but just
they're asking for up to 8, but it's not clear.
Yeah, just default to this current well siting rule until there's a long horizontal drilled. And
well, except that the request asks it could be 8 short lateral wells. So to answer your question, the request does ask for the ability to do up to 8 short lateral wells.
I think that's fine.
So, but then the order would have to be clear that you're actually spacing it for 8 horizontal wells prior to the drilling of a 1280, and then if you drill a 1280, then it converts. And I think, again, the question is, doesn't that have a disincentive to develop for other people anything except 1280s? Maybe that's the intention, but it's a trade-off against.
If somebody wanted to do it ahead of time, then they could always file for an exception location and come in front of the board to get the authority to drill.
Any more questions?
Well, I mean, I just one more word sort of thought for the board to consider. As Mr. Moon suggested, it may be, Mr. Jensen, you've done this a long time, and we started with the Uintah Butte doing horizontal drilling, and that seems to be the best target. Isn't it potentially possible that these other targets aren't going to be as good, or do you know enough now to say that all 5 of these targets are going to be as productive as the Uintah Butte?
Not with 100% definitive, because the well sample set is larger for Uintah Butte and Upper Wasatch, and we don't have all of the data on some other operators on some of the other prospective zones. So far, it looks that way, but there are no certainties.
Okay.
I sure can't sit here.
And as Mr. Brinkerhoff,
there's 100% certainty.
As Mr. Brinkerhoff testified, the sands, the zone above the Uintah Butte has been profitable and has been drilled and developed previously. So isn't it hypothetically possible that this area, which is a very large area, will be developed in the next 40 years with a combination of horizontal and vertical wells? And why not allow for that by overlapping zone spacing?
You don't have to have overlapping to allow for that. I mean, just they can drill them just as well. I mean, right?
Let's let the witness answer the question.
And you're talking before the long lateral well is drilled, is that?
Yes, yeah.
It-
Well, no, either way, before or after. I mean, why not have space? I know that it's commingling, but all of the other producers that have allowed for overlapping have indicated that it's not a problem to account for the production and separate production from vertical, short, or long horizontals. That seems to not be an issue with anybody else. And if that's the only reason, it seems like it provides flexibility to you.
It is not the only reason. I mean, again, we went through like four. It's
Right, and we don't want to repeat that testimony.
It's one of the reasons, and it's working well for us in Central Basin as kind of an overriding umbrella reason.
Okay.
You asked for one more. We gave it to you. You want to ask for one more? Sorry, I
don't know,
think
Mr.
we're
Chairman.
plowing the same ground here, just asking it from a different angle. But
Well, it's a lot. It's a hard question. It's a lot of land, and
what
it's a
is-
lot of wells. And
what is
I
what
don't
is the
have any
point
more.
you're trying to get the board to understand in its simplest form? Do this line of
I'll save
question.
that for closing. I can do
Okay.
that. Thank
All
you,
right.
Mr. Chairman.
Now we're to the board.
So just
Mr. Moon?
Yeah, so an additional reason, so I originally liked the overlapping spacing in Crescent Point's request because they represented that they were going to do a mix of vertical and horizontal wells. And so if there is a high potential, I would say, for future vertical 40-acre wells, then an overlapping scenario is fair to from a mineral interest perspective. But as we've seen over time, vertical wells are becoming a thing of the past. And so they become much less likely to be drilled. So in an overlapping scenario, those that got their vertical wells early, good for them. They get their own production. And then, oh, great, look, we upspaced, and now I get to participate in everyone else's oil. That is inherently, I would feel bad as a mineral owner, collecting all my own and then getting everyone else's too. And so an overlapping scenario, I don't think is a good scenario. And I understand the concern that we don't want to preclude vertical. If vertical, at some point, vertical becomes, economic to reach some resource that we couldn't get with horizontal. Or if horizontal, they just, for some reasons, the intervals don't work out, and we go back and NEWFIELD goes back and says vertical could work. But we don't need overlapping to do that. We just allow for, I would say, do 32. Just put 32 in. That's kind of the way it's been developed, and that's probably what would be we gone back to. We hope not. We don't think that would be the scenario, but if it is, build that into the order so that that's an option. So I've, the overlapping thing, just in this case, I have a hard time seeing how that's good for anybody. But, sorry.
All right. Let's start with, Rich.
Yeah, so NEWFIELD has presented arguments in support of converting rather than overlapping in this case. I guess I just wanted to explore, could you foresee a situation where the geology is different, the state of development, or the state of the nature of the ownership of the ground would actually, you could be in a position to be arguing for overlapping? Or would you almost always be driven towards converting?
I'll answer from the engineering portion and then just look back to Riley for my answer is yes, there's always that possibility. There's not a one size fits all that it makes sense here. It could be completely different where the geology changes. So short answer, yes, that could be a possibility somewhere else, but not for these application lands.
So, if we have, come on up and with the mic.
Identify yourself, please, for the record.
Riley Brincroft, geologist, Newfield. So the issue, so there's many issues, but one of the issues with going overlapping is you'd have some kind of correlative rights issue. We don't want to be fracking into each other or having to make each other whole as we produce the same reserves. And every time you drill, if you're going to have that issue that you have to have that standoff, and you put that vertical well in, then it's a much longer and much more big reserve well that you're cutting out. Meaning to that vertical well that's on a 40-acre, and then a 2-mile long lateral then that would not fit in an ideal scheme. Does that answer?
So that's an argument against overlapping.
Right.
Do you foresee any situation where Newfield might come and ask for overlapping because of some different set of circumstances?
You know, it'd be communitized still. You know, I can picture geologic scenarios that it'd be great to drill vertically. I cannot picture a scenario where we'd want to have it be overlapping, though.
Thank you.
Thank you.
A couple of questions for Mr. Jensen. Would you please go to, let's start with the demonstrative exhibits. Is there a correlation intended between the demonstrative exhibits and Exhibit L? Or was that just a hypothetical using certain assumptions? Because you have I'm trying to figure out how you get to the 582,000 barrels of oil number, just so I can do the math in my head, as compared to Exhibit L.
Which is 4.7 million barrels.
That's right.
That's what you're referring to. All that is taking the 582 times 8, which is the well count, in the column next to the 4.7. So they are consistent in using 582 times 8 is going to get you 4.7 million barrels.
Million barrels, that's right. Okay. Okay, thank you. Now, to Exhibit M. If my recollection is correct, when Newfield came in for the first spacing and then subsequent spacings, the well cost was around 11 million per barrel, per well, in terms of dollars. What's happened between that original drilling numbers and what you know now? Less frac jobs?
You know, a couple main things, and that's, but you're right. I don't remember exactly either, and I testified to it at the 139, 134, but around 11 or 12 million. You're correct. So a significant reduction, and a lot of it had to do with the price drop in oil, and so service company costs dropped accordingly. So when we came in 139, 134 was a higher oil price environment, but you see costs come down. So that's part of it. Technological changes, learnings over time of Newfield, in which they just changed well design slightly to make it more cost efficient.
Okay.
Those two factors.
Okay, next question I had was that on the rate of return, I'm really kind of alarmed at that number, because my understanding was that if you got below about 40% ROI, you would, you're, as a state or as a field, you would have a hard time getting capital allocation from the headquarters of the company as compared to other fields. And so
the best I can answer, internal hurdle rates, you start to get into a sensitive issue that I can't answer that specific question, but my testimony is, and their full intent is, at oil price is a little bit higher than this scenario, but planning to drill this now, I mean, with a rig. So that obviously fits their criteria right now. And I'm saying that without divulging their hurdle rates or how they look at it with budget.
I understand that, and I'm not asking you to get into any proprietary information, but it does affect my comfort level with a long-term order. I need to put you on notice of that.
Why? Can I just ask why that concern?
Yeah, of course you can. If you can only get the capital, I mean, if you're getting 40% is the rule of thumb in the Bakken and North Dakota.
That's their issue. Why would that affect us in?
Because the representation or the understanding of the testimony on my part is that you're going to have one rig drilling this field for a long, long time, and you're going to have a lot of leases, HBP, held by production for a long period of time, and I'm just, and the other factor of it is that this is a pilot project. We don't know all the answers. And when you don't know all the answers, you don't put things in concrete that last a long, long time. And I think this is that 22 number really is scaring me a little bit.
But what we're doing is giving them the opportunity to go out and prove out and drill long horizontal wells.
Of course, and you need to give them the time to do that. Yeah. But is it 80 years? Is it ad infinitum? Is it, or should it be, because it's a pilot project? And I'm going to let Mr. McDonald answer this, or the witness answer it, but as for me, having been in the room where the capital allocation is done on a multi-state basis, I have to raise my hand. Do you agree with that? It just sets off on a little bit of a concern here about a long-term order. I mean, the testimony is what you have to go on, but it is a concern.
Just speaking from a royalty owner's perspective, if they just drill one horizontal well, in my opinion, they earned that 1,280. That's the way we've always done it, and it's not that until they drill it, and so
I understood. You know, that's why we have an expert board. We do understand a few things.
Without, again, divulging any proprietary hurdle rates and stuff, the only thing is actual evidence that even lower oil prices, we have kept a rig drilling in Central Basin under the same type of order for, it was actually a larger DSU order. So Newfield believed in it enough and continued with one rig drilling up there. We would hope it would be more rigs, but evidence shows
that's right. And at your original hearing, I did the numbers, and I plugged in the number of $90 a barrel with the differential. So yes, you've got a different scenario. I understand that. What I'm doing is I'm asking these questions to learn in something that's new to us. I'm not challenging your decision as much as it is I don't understand it. There's a part of it that just has alarmed me a little bit that we're getting numbers, the rate of return that are 22% when Axia, last month or a month before, were giving us 70% or 80%.
Well, I think Axia is being a lot more optimistic in some way. I mean, because they're drilling using similar technology. They're both drilling long horizontal wells. There's a different play. Axia is further up north. Maybe there's more pressure, and so they have numbers to justify higher.
And their well costs that they testified was about $9 million.
Yeah, they were showing higher well costs. So how they get there, I don't care. I really don't.
Well,
sorry.
Actually, quite honestly, what you just said actually has a lot of weight with me. Huh? A lot of weight. Okay. With that, Mr. McDonald, would you ask that your exhibits be admitted?
Yes, I'm assuming the board has no further questions, Mr. Jensen?
I don't think we do, unless seeing none.
All right.
First of all, let's do your redirect. and then ask for the exhibits.
I have no redirect of Mr. Jensen.
Okay, then let's get your exhibits out of the way.
All right, we would move for admission of exhibits A, B, C, D as corrected, and we will submit a corrected one to correct that typo on the order, and then E through M. We are not asking for admission of the demonstrative exhibit.
Okay, and then O, the BLM letter?
Unless it's already considered part of the record. I would assume that that's the case. But
let's call it Exhibit O.
okay, Exhibit O, then we would add that as well.
Okay. Division?
No objection. And I'm
going to get to the EP letter. I'm going to get to the EP letter separately.
Thank you.
And also, I think I misspoke, Mr. Chairman. It's Exhibit N, not M. N as in Nancy.
Thank you. I interpreted it as N.
Yes.
But that clarity helps. And for military people here, that's November. Okay, so board members, any problems? Okay, A through O.
After you're done, I have one more question.
A through O are admitted. Okay, now as to the EP letter, I'd like to hear from the division on its position. I'm inclined to tell the board that we can let that in, but give it the weight we deserve, recognizing it's out of time, and give it maybe no weight. It certainly doesn't deserve full weight, but it would be helpful, and I'd like to hear from the division what's your position on that.
Well, I'm not sure.
Did I say, is it actually or EP?
It's EP.
Correct, okay.
So it is EP. It did come in on the 29th, and so it caught the division a little bit by surprise, but I don't know that there's anything inappropriate. They're not filing objections as, if they had just shown up here, they could have testified to that. True, we don't have someone here to cross-examine, but I think it should be admitted.
Okay, we understand your position, Mr. McDonald. Board members, you're comfortable with letting it in and giving it the way that we deserve, we think it should have? Okay, then I'm going to rule that that the EP letter is admitted, and that note that the we will give it the weight we deem appropriate for that. You also asked about judicial notice of the testimony.
The testimony and the exhibits that were admitted into evidence in the 139-134 hearing.
And that is so admitted.
Could I address that question?
Yes.
You've included the findings of fact and conclusions of law in the request for agency action. Are you asking, I mean, I don't remember what the testimony was. Isn't that sufficient to have the findings of that order accepted or adopted by the board without the testimony?
It's not necessarily the findings. It's the technical testimony and the justification as well to show the consistency between it. The request simply quoted that to outline why an extension was appropriate, but there are some differences here.
And I'd object to the fact that it's 2.5 years ago, and I'm not sure all the testimony was given there. I wouldn't have a lot of questions about it at this point in time. Things have changed.
Okay, as to the orders that were set forth in Exhibit B, they are admitted. As for the judicial notice of those, all right, if you want to, I think we're going to take a day or two to decide this. I would like you to address the time crunch to get an order out, but I don't know that we're going to be able to do it today. So would you like to press that issue?
I'm not going to press it if it's really going to be an objection, but I think it's inappropriate to take the judicial notice if you're going to extend and adopt the order and the findings of fact, because that was the basis for those findings of fact and the legal conclusions. That's why I'm asking for judicial notice of it.
Mr. Alder.
You're asking for judicial notice of the findings of fact and conclusions of law that were adopted by the board in that order.
I was asking for judicial notice of the testimony and exhibits which form the basis of those findings of fact.
I just don't think, I think that's, I don't know that we've done that before. I think it's kind, maybe you probably have, Fred, and I apologize, but it seems
We'll take that
extraordinary.
issue under advisement.
That's fine.
And
You've heard the
that'll be
arguments
something,
on
and we'll rule on that. Okay, we're now to the division. We're just going to keep motoring on.
Thank you. And let me say that I think the division, of course, is grateful for Newfield's interest in developing this area, grateful for the past experiences that the division has had in spacing other cases, and I think that the only reason that this might have a slight hiccup from the division's point of view is that in the interim, since the 2.5 years ago when they spaced the land immediately to the north, we've had 3 spacing matters for 1280 wells where we've adopted overlapping spacing. And, you know, I'm not an engineer, and I don't know exactly how much trouble it is to have these wells getting close to each other, but other companies have said it's compatible, it can work, and it actually has advantages in those areas where they've requested overlapping spacing. There's something to be said for this board and this division eventually adopting a consistent order as to how to deal with horizontal wells. As I hear the testimony, I don't hear a lot of problems with overlapping spacing. It obviously pays to everybody's advantage to maximize production. And so if there's a concern about setbacks, it's going to be solved in the way that maximizes production. The only question is it really that hard to account for the production from wells in a fair way to all of the mineral owners? So there's that side. Now, Mr. Moon made a good point that if these wells, all 40 wells, or probably even just half of that many, are drilled out, everybody's better off than, and it's not fair to let that 40-acre vertical well recover twice. That's not fair. But it also could be unfair to hold 1,280 acres with one well for another 20 years, as the chairman pointed out. And how do you even that out? That's one thing that the other orders have included we haven't talked about, which was they had on the Crescent Point, they both had a 5-year sunset provision and a 1-year reporting provision. Might be helpful in this case since we, as we've all agreed, don't quite know how this is going to work, and it would certainly be wonderful we had 10 drilling rigs in here and producing it in a hurry, but it would be possibly unfair to mineral owners if we just have one rig and the price of oil stagnates for another 10 years. So it seems like maybe having a reporting, having a sunset, and I still am, I think the division really can see both sides of the overlapping disadvantages and advantages, but I think we felt as a matter of consistency and overall on the balance, we would favor the overlapping spacing. I guess there is the middle ground that happened in those two, which was the overlapping was on 640-1280 rather than 40-640-1280. That's sort of a middle ground that hasn't been addressed the board might consider.
I think the board still considers this to be under the pilot project, since we haven't made any final conclusions as to lessons learned and how we're going to proceed on a long-term basis. Does that affect your comments at all?
No, I think we agree. Thank you.
Board members, any questions of the division? I think it was just.
I'm assuming that was the division's closing as well? Okay.
Right. Okay, then we're back to you.
All right.
So, you want to ask a question?
Yeah, I don't know if it's necessarily of the division. So What would be the drawbacks of just allowing up to 32 vertical wells? Don't think we're ever going to need them, but allowing it so that we do continue the status quo. Would that alleviate your concern, Mr. Rogers, that somehow by allowing 40 horizontal wells, we are discouraging or upseating possible vertical wells? If you just allowed the 32, which is the status quo.
Well, I think you're just going to do on well siting then, right?
Mm-hmm.
Then you're back to saying, is this really spacing, or how are we going to allocate on that?
Well, that's somebody legal can
that's
figure
something we
that
talked
out.
about at the very beginning.
I don't care. I just say 32 is the status
16
quo.
per section.
Yeah.
But you bring up a good point, if I might, Gordon, and that is, how's the division going to operate if you get a race to the courthouse in effect, where the division's got a horizontal well and the division then gets a vertical well, or vice versa, and how do they? I think that some of the lessons learned is we got to sit down and talk about that, or maybe bring it to the board so that we can pick the sequence of how things are going to happen and make an informed decision, rather than allowing someone to go in and just force the hand.
That question exists either way, whether you do 8 or whether you do 32. I guess my only question is, with 32, does that alleviate the division's concern, and what would that mean? How much would that matter to NEWFIELD? Because we're talking about flexibility in these orders, so that we protect correlative rights, and so that we have the maximum production. Why not allow that flexibility? My question is, why not?
I know I can't answer that without.
Yeah, it's more of a land.
Well, Mr. Moon, I would say, why 32? I mean, say there were no horizontal wells here, then you would come in for a spacing order and you would prove why it should be 40, 160, 3,
Yeah, well, there's just hundreds of wells in this area already, mostly to the south, and they've been on basically 40-acre basis, sometimes 20s down in Monument Butte, but
usually they come in and they get a board order to define a spacing unit, and here we're just sort of throwing it out there. I don't know. That's something I'd be concerned with.
The real problem is the question, and maybe we can address it in another way, is that it's not clear when this order becomes effective, because it appears that prior to drilling a long lateral, and maybe Mr. McDonald can explain, it's status quo.
And I'm just saying,
to a limited extent, it's not, because they want to allow 8 horizontal wells.
8 is not status quo. 32 is status quo, basically, for this area.
And the short horizontal also is
status quo.
But that only changes once the long horizontal well is effect. It's status quo right now. Yeah. So if they wanted to drill, if somebody wanted to come in and drill a short lateral well, it would be the same thing that NEWFIELD did with the Knoll well. They came in and sought an exception location for you guys.
So it's already going to be 32. It's just after the order is in effect,
then it's
allowing up to 32. That's all what I'm saying. Yeah.
In the interest of time, Mr. McDonald, can we give you your?
Yeah, I'd like to address some closing issues to try and do this. Okay.
And you can tell we're struggling.
Right. No, and I'll try and be brief.
And just in the overall concept of this, we have a lot of regard for and faith in NEWFIELD, witnesses, exhibits, but just how to manage this whole idea of horizontal drilling as compared to vertical.
Okay.
Is the part that I'm struggling with.
Well, first of all, I want to make sure that everybody keeps this in mind. Nobody has objected to this other than EP's letter, which is in question. Nobody. This has been out there since September, and nobody has raised an objection to what NEWFIELD is asking for here. So you have to keep that in mind. That's probably the first thing I want to point out. Secondly, I think NEWFIELD has laid out the case more so than anybody else why conversion should be appropriate here. And one of the biggest elements there is the issue of communication between vertical and horizontal wells. This board set in other matters a 330-foot setback there. And Mr. Jensen testified that he didn't see anything, and I dare anybody else to say, where did that come from? What's the testimony that 330-foot setback is appropriate? Because an overlapping drilling unit is always based on how are you going to prevent communication, because you're allocating production on one basis from one well and production from other wells on another basis. And if there's communication, you're going to open up Pandora's box here.
That's the problem in Oklahoma.
And there's issues with that. So a conversion takes that away from the standpoint of allowing the flexibility of the well locations. It doesn't preclude vertical wells, okay? And if by chance there is communication, correlative rights are not adversely affected because everybody's sharing on the production. So if the vertical well is enhanced and the horizontal well is a little bit down, everybody still has the same benefit. It equals out. That's the basis for this. Now, you also say, well, what if plans change? What if Newfield says they want to go to verticals? Or, in other case, Newfield, say, sells out the field and somebody else comes in. And I will give you a prime example of how you deal with that. If you recall, EP and Bill Barrett came in for the Blacktail Ridge area and the Lake Canyon area and asked for 8 vertical wells per drilling unit because they were going to do a vertical well and they wanted the increased density. And that was 4 or 5 years ago. They sold out to Crescent Point. Crescent Point came in last month and asked you to start doing horizontal wells. That's how you do it. If you want to change the plan and somebody wants to come in for vertical wells, they come in front of the board and change and modify and vacate the order and justify why to do it. That's the easy way to do it. The other plan is, as far as your timing goes here, one of the things is if you're going to authorize 40 wells, that gives the company and company level to know where to put the infrastructure. Okay, and do long-term planning because they know they can drill up to that many wells. That's an important factor here. Okay, the other problem with it is if you start allowing up to 32 vertical wells, you've got 32 well pads that are potentially owned without common facilities and everything else. You want that environmental footprint. There's a lot of concerns with what's going on here. This is why Newfield has thought this through. They're the most experienced operator out there. They know what's going on. This is why this justification has been made, and I think they've set their case out very well. There's no objections here. So that's why we would ask the board to go ahead and adopt what's said here. I know there's bigger issues here. I know you're struggling for consistency, and I understand the division's point with that as well. But, you know, this is the situation with what's in front of you today. So we feel that Newfield has made its case for you to approve the request as stated, and the justification for it, and the authorization to go ahead and do this. And there's plenty of opportunities and other methods to do this. Final point I just want to make was the same point I made earlier. As a practical matter here, when you have a working interest owner who is a substantial majority working interest owner here, who is going to propose and who is going to drill a vertical well? Who's going to do that? So while we talk about in hypotheticals, and if you talk about it strictly on a theoretical basis, I understand the basis for this. But step back and take your blinders off and look at the practicalities of it. That's the other factor here. There's not necessarily an objection to going ahead and doing 32 wells. And people could do that right now. But once you start doing the long lateral, then you start going, if you start saying people can put in 32 wells, then where are you going to locate the horizontal wells? How are you going to do that? This order that is requested is a logical development plan. It protects correlative rights and it prevents waste, which is what your statutory mandate is to do. So we thank you for your time and attention.
Thank you very much. Thank you. Okay, with that, let's move to agenda item number 2, docket number 2017-015, cause number 139-145, which is a matter that is linked to this matter to the extent that we can resolve it in our order on agenda item number 1. We're going to continue that until that the order comes out. But in all intents and purposes, that will be involved in this agenda item number 1. In agenda item number 3, docket number 2017-024, cause number 139-149, regarding Axie Energy. That matter has been continued to the February 28, 2018 board hearing. With that, I believe that concludes our business for today. And so I motion to adjourn to our open meeting discussion, and working lunch is in order. All in favor, say aye.
Aye.
Come on, a little louder.
Aye.
Okay, any no votes? Okay, that is unanimous, and we may be able to get that discussion out today, but I think we'd like to talk about it for a couple of the agenda item number 1. We may be able to get a decision out today. We'll try. But we'll try
Yes, any because of the drilling plans, Mr. Chairman, a decision as quickly as the board could do is be appreciated.
But no later than the 1st of next week. Okay. Thank you very much. We are adjourned. Grab your stuff, if you will, and.